Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1161 et al. Deborah Evans et al. Petitioners versus Federal Energy Regulatory Commission.
Good morning, counsel.
Good morning, Your Honor.
Counsel arguing on justiciability. Do you wish to proceed?
Yes, ma'am, I do.
Please do.
Good morning, and may it please the court. First up is justiciability. Landowner petitioners, including the state of Oregon, had standing when they petitioned for review of Pembina's certificate, which FERC does not contest, and subsequent events have not mooted their claims. This project and previous iterations have made petitioners' lives miserable for more than 15 years, threatening to take their property and thus forcing them to put all of their plans on hold. For example, Richard Brown has not been able to plant an orchard, and Pamela Ordway has not been able to plant a vineyard because they don't know whether they will be able to reap what they have sown or instead watch Pembina tear up and cut down everything they planted. FERC argues petitioners lost their standing because Pembina failed to obtain 2 necessary permits for the project, meaning that Pembina cannot build it. And this led to Pembina saying that it would not condemn petitioner's property while it paused to think about what to do. The issue of building the pipeline is a complete red herring. Those permit denials mean that Pembina, at least for now, can't build the project, but they have no effect on Pembina's eminent domain authority.
So what if either FERC or this court said that imposed a condition on the certificate order that can't proceed with eminent domain proceedings at this time until they move the court or move FERC to do so in order to, I guess, after they've completed their pause and reassessment. If that were the case, non-justiciable?
No, Your Honor, because the issue would still have to, we raised that issue. Pembina already moved for an abeyance based on that. And it's not clear that, I mean, if FERC has said it does not have the authority to stay eminent domain proceedings under a certificate. They've repeatedly said that. They can stay.
Yes, but Mr. Bookbinder, Pembina would have the ability to agree, wouldn't it? And so,
yes.
So
yes.
What is your position if Pembina were to represent that it would agree to a condition like the one that Judge Wilkins indicated?
That would relieve the immediate problem for landowner petitioners, but it would not eliminate the injury that they're suffering right now. It merely prolongs the condition they've existed under for 15 years. Pembina won't start condemnation. It can't start condemnation. Great. They've been thinking this pause now for 8 months. And we have no answer. Is it going to take another year, another 2 years? We don't know. And
but let me just be clear on my part of the question as to piggybacking on what Judge Wilkins said. I'd understood that Pembina moved to hold the case in abeyance in light of the certifications. And there was a point in, I believe, the landowner's brief in which there seemed to be an agreement that if the necessary conditions from the landowner's perspective were included, that the court could and should hold it in abeyance, perhaps. In other words, if Pembina were to agree that it would not exercise its eminent domain authority, not just during the pause, but even if they decide ultimately to cancel the project, why isn't that good enough for the purpose of holding the case in abeyance and then we can all go home?
Because, Your Honor, we agreed to that condition and that would have eliminated all of the problems many months ago. Now we're faced with the idea that there can be a stay of condemnation and there won't be condemnation until such time as this court issues its final ruling, or until, unless FERC decides to vacate the certificate. It's the amount of time that it takes. We don't want we want this case adjudicated to give them some finality. Every day, these people are living under the threat they've lived under for 15 years. They want this decision. They want this case over.
But
And
wouldn't that eliminate ripeness, Mr. Bookbinder? I mean, you know, I do understand that they want the case to be over, but if we set up a set of circumstances in which there was no opportunity for the harm that your clients are focused on, the condemnation to occur, then wouldn't that solve the problem for the foreseeable future? And to the extent the case was held in abeyance, they could come back if it looked as though the project were going to move forward.
yes, Your Honor, but we would request that any such stay, even if Pembina decides to cancel the project, we have to ensure that the stay is effective through that period of time, because they would still have eminent domain authority. If they continue with the project, obviously this case will be adjudicated.
Well, let me ask you, a motions panel denied the motion to hold the case in abeyance. And our precedent, including an in-bank, says that's the law of the case. Why aren't you arguing that as well in response to Ferc's brief now seeking abeyance as a solution to what it views as the ripeness issue?
Because, Your Honor, frankly, I did not know that a decision of the motions panel was binding on the merits panel.
Well, if you look at DC Circuit precedent, I can cite you cases where we have said is the law of the case. And the only question I would have is, in that situation, a motion was presented to a motions panel. A staff attorney memo was written suggesting that the case be held in abeyance. And the motions panel rejected that recommendation. And we have noted repeatedly in our precedent that the merits panel is bound by the motions panel decision under the law of the case doctrine. Now, the only question I would have here is, and I guess I'll ask Ferc, since you aren't familiar with this line of precedent, whether or not we can distinguish those cases here, because so far as I can tell at this point, there is no indication that the motions panel as such was expressly dealing with the ripeness question. Although it is clear that the question whether the project would ever go forward was clearly presented. And in one sense, that's 6 of one, half a dozen of another. And therefore, since the motions panel denied abeyance, we ordered full briefing. And in oral argument, I wonder why we're discussing this now.
Your Honor, by the way, ripeness was raised in the abeyance motion. And in fact, the abeyance motion relied entirely on the same case, the Devia case that Ferc relies on here. That motion was brought by Pembina. That's the only distinction. But the arguments they make are absolutely the same.
Mr. Bookbinder, can I just be clear? Were the arguments contemplating the kind of agreement over conditions that we are discussing now? In other words, I understood Pembina's, or excuse me, the petitioner's rejection or opposition to the motion to be that it didn't have these sorts of conditions. And so to the extent now that Pembina may be amenable to the conditions that the petitioners want, I'm wondering if this really is the same scenario that the motions panel considered.
Yes, if Pembina were to step forward and say, yeah, and accept a stay until this court issued its opinion, or until it decided what to do with the project, or rather a stay of eminent domain whether or not it goes forward with the project until such time as this court issues its decision.
Then we would have a joint, basically an unjoined or unopposed motion, because you would agree with that, right? And so now it's not even really a motion, it's more like a voluntary cessation from both parties pursuant to these conditions.
If Pembina rejected that offer from us last time, they have not participated in the merits briefing. We don't know what they're thinking. But Your Honor, I want to go back to the issue of the current harm. It's these people, you can't sell your property if the buyer thinks, oh my God, I don't know what I'm buying. I could be buying something where a pipeline is coming through. They can't use the potential areas because the Pembina claims easements on them. This is a serious, infringement on their property rights currently. It's not a question of an abstract issue, and it's an issue they dealt with. And I have to emphasize that 15 years, we even included, it's not in the joint appendix, but it is in the record, a report by a geriatric psychiatrist talking about.
Well, let's stick to the record, if you don't mind.
Yeah, by the way, that report is in fact in the record, Your Honor. So, if we can get an agreement from Pembina that they will not exercise eminent domain until either this court issues a decision or the FERC vacates the certificate, then the worst of the harm is eliminated, but certainly not all of it.
Well, I know that the state of Oregon has some other issues as to why we should go forward, and that type of condition, barring any exercise of eminent domain, does not resolve other issues that were decided before the certificate order was issued, that the state claims may harm it. So I'm concerned that at this stage of the game, this court is trying to craft something as distinct from the parties having had the opportunity at the motion stage to examine all these issues, and before FERC to have examined them as well. And FERC apparently, and I'll ask counsel for FERC, I don't know what the phrase is, but was not concerned about Oregon's pre-certificate claims.
Your Honor, what the state of Oregon is saying is that under the certificate, Pembina can still engage in activities that would result in discharges to waters of the state, and that would impact.
I understand.
And such a stay would have to, I assume, include a stay of any such activities.
Well, that's what I'm trying to get at. I think this is complicated. All right. There are a lot of aspects to this type of project. And for us on appeal to try to craft an order, the next time, there'll be a motion saying, well, the order didn't cover this and we need to amend it. So I'm a little troubled by that. The other thing I'm concerned about here is the harm that the landowners are claiming. I don't deny for a moment that they are suffering the types of harms you have suggested. But in terms of what FERC's statutory obligation is and what it said in the certificate order and the rehearing order, where it acknowledged that there were harms to the landowners, but that it was satisfied, weighing the benefits versus the harms, that the project should go forward. So my question focuses on, I know somebody wants to plant trees, I know somebody wants to sell their home, but that kind of relief is not the kind of relief that I understand FERC normally to offer. I mean, FERC would not, for example, pay your clients the difference between fair market value and assessed value, for example, or they would not pay for the planting of trees. So in terms of what your clients seek, as I understand it, the only remedy that's going to protect them, as you presented to us, is to say that the project should not go forward for any number of reasons, citing what you will say are either errors by the agency or arbitrary and capricious action. Do I understand your position?
Yes, Your Honor, we're seeking vacatur of the certificate. That is correct. Based
And
on
absent that, the harms that you say have been going on for 15 years, and I'll take that as a given, they will continue.
Yes, they will, Your Honor.
Unless this certificate is vacated. And
Correct.
as FERC points out, given the demand and the economies involved, if this proposal doesn't go forward, somebody else is going to come forward. And while maybe the route will change a little or something like that, the quote, harm in this broad way you've defined it does not go away.
Your Honor, first of all, it goes away for the parties, before you in this case. Moreover, FERC's statement that if they don't build this, they'll build something out, which my colleagues, they'll build something else, which my colleague, Mr. Matthews, will deal with, is absurd. FERC presents absolutely no evidence in support of that statement. It is simply an assumption. Well, if these people don't build it, someone else will.
Well, this particular party has been trying to build this for many years, correct?
Correct.
And obviously, I won't say obviously, but I'm assuming it sees this as a very profitable endeavor. The notion that no one else would come in strikes me as a little unrealistic, and certainly FERC is in a better position than the court to make that kind of judgment. So I'm just concerned in terms of the harms, exactly what relief your clients can in fact get in terms of the harms as they have described them in their affidavits and in commenting on the draft EIS.
Your Honor, here the petitioners are injured by this certificate. And whether if this certificate is vacated, another company tries to build, or this company tries to build a facility somewhere here again or somewhere else, we'll have different petitioners. Moreover, FERC says this is the most desirable location. So it's not clear to me that if they can't build it here, that a second or third best location would make the same business sense to them. I can't speak to their thinking, but.
Mr. Bookbinder, can I ask you, are you speaking today about justiciability with respect to all of the plaintiffs? Because I discern a difference between the harms alleged by the landowner and the states and the harms alleged by the tribe. So I'm just trying to understand whether you are in a position to answer questions about the latter.
No, Your Honor, I'm not speaking on behalf of the tribes as to justiciability. Our standing and justiciability arguments are based on the strongest possible ones, which are the landowner and the state of Oregon's arguments.
But don't the tribes, to the extent that they have a different claim, the claim about cultural heritage and resources, don't they have to have standing independently?
Yes, Your Honor, they do have standing to do that. They do have standing to raise the National Historical Preservation Act claims that they do, which is that FERC should not have conditioned its certificate on going back after the fact and doing the NHPA section 106.
I understand that's their claim. What's their basis for standing, their injury? What gives them the right to make that claim in this court?
Is that their cultural resources may be damaged by the by the construction and operation of a pipeline long before the NHPA 106 consultation is completed.
What affidavits do we have from them, or what evidence in the record can we point to from them to establish that as a fact?
I am not familiar with the affidavits that they placed into the record on that.
I couldn't find them. And I suppose we'll ask counsel whether or not under this court's precedent, when this court is unable to determine standing, where to the tribes, it may be obvious. Nevertheless, the court needs affidavits. They could file affidavits now.
And I will say,
I'm citing the American Libraries case decided by this court.
and of course, any such affidavits would also have to address the issue of eminence, because, you know, even a supported contention that they would be harmed if the pipeline was built seems to me to run into a little bit of a problem in this situation, where it's pretty clear from everything that has been submitted that the pipeline is not going to be under construction anytime soon.
Yes, Your Honor, their injuries would result from the construction, unlike the injuries to the state of Oregon and to the landowners, which stem directly from the threat of eminent domain. And in the Oregon's case, in addition to the threat of eminent domain on state lands, it's also the issue of Pembina allowed, even while pausing, even though it cannot do, quote, construction, it still is allowed to do activities which Oregon has said would or could result in the discharge of pollutants to state waters. And they do not have the certification, the 401 certification that justifies them doing so.
Anything further?
No,
No, Your Honor, not on the issue of justiciability, except to say that ultimately what FERC, by moving to dismiss this issue on the basis of either standing, which was determined as when the case was started, or on ripeness, is ultimately an attempt to deny petitioners their due process rights, allowing Pembina to take their property without there ever being an adjudication of the legitimacy of the taking, whether the taking is proper under the Natural Gas Act.
So we have your argument in your brief on that.
Yes,
Do my colleagues have any further questions of this counsel?
no, Judge Rogers.
No, thank you.
Thank you. We'll give you a few minutes on rebuttal. Counsel for FERC?
Yes, good morning, Your Honor. Susanna Chu for the Commission. Thank you for hearing us today. I'd like to start with the eminent domain issue. I am sensitive to the landowners' concerns, but I do want to point out that Oberlin says that uncertainty about eminent domain does not necessarily equate to actual harm. The court in Oberlin said that the harm occurs when the petitioner is put to the choice of either selling land to the pipeline company or having property condemned. And here, the project is at a complete standstill. It cannot be resurrected without the state of Oregon's approval, because these two critical state authorizations have been denied. And of course, as you know, the pipeline has paused development. And in the 8 months since it stated that it was pausing its development, my understanding is it has not sought to obtain any of the other outstanding permits for this project. It has initiated no eminent domain proceedings, and it has done absolutely nothing to advance this pipeline project.
And I understand exactly what your position is, that the court should, the motion to hold the matter in abeyance was denied. What are you asking the court to do now because of this and the pause? To dismiss these petitions, to hold them in abeyance? What does FERC say is the appropriate thing that we should be doing?
Right, Your Honor, the commission believes that either the case should be dismissed for lack of standing or it should be held in abeyance. And if the court finds it appropriate, as Judge Rogers was mentioning, to stay the effect of the certificate while the case is in abeyance, that is, of course, within the court's discretion and appropriate. And I think that holding the case in abeyance while staying the effect of the certificate would eliminate any potential harms, and I think it would alleviate the petitioner's concerns.
And is it your position that FERC cannot impose that condition on the certificate order itself and say, well, since you are taking a pause and since you want to hold the DC Circuit petition in abeyance, we're going to amend the certificate order to say that you cannot proceed with eminent domain proceedings absent, relief from us?
Well, Your Honor, I don't think that the agency can do that while this case is pending before the court, because jurisdiction lies with the court. Of course, if the court directs the agency to make that order upon dismissal or upon abeyance, of course that's appropriate. If directed to do so, the agency will, of course, carry out the court's directive.
Well, here's the problem that I have with what the agency is doing. These homeowners, the only merits defense they have to an eminent domain proceeding is my land isn't within the area of the pipeline. They essentially don't have any defenses to an eminent domain proceeding when there's a certificate order that's been issued. And do you agree with that?
No, Your Honor, I don't think I agree with that. Because while it is true, excuse me, while it is true that a district court cannot entertain a collateral attack on a FERC certificate order, this would not be a collateral attack on the merits of the certificate itself. This would be a defense relating to the pipeline's lack of state authorizations.
I understand that. What I'm saying is you're saying that in an eminent domain proceeding, they could use the lack of the state authorizations to prevent eminent domain, to prevent the condemnation?
I think it's possible, Your Honor. I'm not aware of any case that has had that issue raised. But I think it's certainly a defense that a landowner could bring.
I'm not either. I mean, the problem that I have with FERC's position, just to be candid, is the only real defense that we know that they have would be to vacate that certificate order. And the only way that can happen is by us hearing their petition and adjudicating their petition.
I'm not sure about that, Your Honor.
FERC is taking the position that we should just hold all of that in abeyance while not preventing them from not preventing the pipelines from going forward with condemnation proceedings. And it seems like you are putting the landowners in an untenable position by adopting that litigation strategy. I can see why the pipelines would want to adopt that litigation strategy, because they can argue in this court, oh, don't hear the certificate, while they argue in another court, condemn the property, and we have a valid certificate, and they can't challenge the certificate here, so go forward with the condemnation. They're basically, in a legal position where they're kind of talking out of both sides of their mouths. I don't understand why FERC would want to join them in proceeding in that fashion.
I appreciate your concern, Your Honor. I understand it. I think that there are a couple different options for the court to alleviate these concerns. The first is the court could hold the case in abeyance and place a stay on the certificate order and any eminent domain proceedings. So that would resolve the eminent domain issue. Secondly, the court potentially could choose to dismiss the case as moot and direct the agency to vacate the certificate order. If the court chooses to go that route, that is within the court's discretion.
I don't understand.
I think that basically,
I don't understand the second route that you just crafted. How could the court dismiss the case and order relief pursuant to the case? I thought maybe I misheard you. I thought you said the court could dismiss the case as moot and order vacatur of the certificates.
right, Your Honor, I think my understanding is under Allied Signal, Munsingware, similar cases, I believe that the court could find that the case is moot and not justiciable. It could order the certificate to be vacated if it wanted.
That's under like a voluntary secession theory, but we don't have the intervener, a pipeline company, saying they've said that they paused, but they haven't said that they've abandoned the project, right?
That's right. Well, the pipeline in their motion for abeyance said that they have not filed and do not intend to file any eminent domain proceedings. And they've said that they've taken a pause. They have not represented to the court that they've canceled the project entirely. But in light of the state denials, it is clear that this project is not going forward. And while I'm sensitive to the petitioner's arguments, what petitioners are seeking is effectively an advisory opinion from the court.
Well, Oregon's denial was without prejudice. So that leaves it open, it seems to me.
Right, Your Honor.
Come
Yeah,
back. And I thought the landowner's problem was a pause, but the pause and when it ends is defined by the project owners, not Ferc, not the court. And that's the problem.
right, Your Honor. But I still think that there are remedies. The court can address the situation without proceeding to adjudicate all of the merits in this case. I think that while we are sensitive to landowner concerns, it is purely speculation that the pipeline might try to conduct eminent domain outside the scope of this certificate, for example. We know that under the Natural Gas Act, under Section 7H, eminent domain is only authorized for the land that is necessary to complete this particular project. That is the one that is authorized by the commission. The commission's order is not a wide-ranging authorization for the pipeline to do anything it wants and to condemn any property that it wants. It is, of course, limited to the scope of the orders itself.
So, Ms. Chu, if that's the case, we don't have the certificates. The project is on pause. I'm trying to understand if we still have a live and ripe controversy to review if the company agrees not to exercise its eminent domain and the petitioners are fine with conditions that the company would agree to concerning not exercising it through the pendency of any pause up until, any determination is made, whatever other conditions there are to ensure that there is no exercise. I mean, you seem to be saying under these circumstances, it's obvious that there's not going to be an exercise. I'd like to take it a step further to say, do we still even have a controversy where we've had representations from both sides about the extent to which we wouldn't have a dispute, at least as far as the landowner petitioners are concerned, if we nullified somehow through an agreement the possibility of eminent domain, of condemnation? I just don't understand what's left from a justiciability standpoint if the harm is abated through agreement of the parties.
Right. Yes, Your Honor, absolutely. I think that you're absolutely correct that we don't have a live and right controversy before us right now. There is really nothing for the court to adjudicate under Article 3.
I mean, we may, excuse me, let me just be clear. We may have it right now because we don't have this agreement that I'm talking about, right? I mean, we don't have an agreement. So what the petitioners, at least the landowner petitioners, are proceeding under is something that I think, I was going to go back to your original statement about Oberlin. You know, uncertainty about eminent domain may well be a harm. It was just not one covered by Oberlin. I didn't read Oberlin to suggest that being put to the choice is the only harm that one could have. And what the landowners are saying is, in this situation where we don't have an agreement by the company not to exercise its domain under the conditions that we think are appropriate, we are living under the threat that they may well do so. And you might say that's speculative, that is probably not going to happen. All that's fine, but it still is a possibility. And so what I'm trying to understand is if the company were to eliminate that possibility in a way that was clear, that the petitioners accepted, that, you know, abated the harm from their perspective, do we still have a case from the landowner's point of view?
No, we would not, Your Honor. I think you're absolutely right that a commitment by the company would abate any harm. And I think
so
we already have.
We ask the company? Can we ask the company what their position is now after the petitioners have come back in their gray brief and said, you know, well, the problem is these conditions weren't there, but maybe if those conditions were there, we'd be fine, says Mr. Bookbinder today. Why don't we ask the company?
I think you could, Your Honor. You certainly could. However, the company has already said it has no intention of initiating eminent domain. And also the court could direct the company. I mean, it could stay the effect of the certificate, which would stay any eminent domain proceeding.
Let me ask counsel, though. I thought the company's commitment was so long as we, the company, is holding this matter in abeyance, we do not plan on exercising eminent domain. And what the homeowners, landowners, argue is the first clause is left entirely to the discretion of the company. And that's no protection whatsoever.
Well, yes, Your Honor, but this court has the authority to make that binding on the company. That is absolutely within the court's power.
I'm concerned about the appellate court trying to come up with sort of finding facts and issuing an order without sending it back and letting all this be fleshed out before the commission. And I'm troubled where this matter has been pending before Ferc for a long time. And everybody's had a chance to raise all these issues that now, after the motions panel denied the motion to hold the matter in abeyance, we're suggesting, not with any new facts, as in a case we just heard, not in a change of position by the government, that we ought to sit as sort of an appellate Ferc and try to flesh this out among the parties. That's normally not our role.
Right, Your Honor, the agency is not asking the court to flesh out the facts here. What we're saying is that there is no live, ripe controversy for the court to adjudicate, and the court could it could dismiss, it could hold the case in abeyance.
Would you say
to
that
its satisfaction
as to the state's arguments as well?
Yes, Your Honor, absolutely, as to the state's arguments as well.
Why?
The state, as I understand it, is concerned that any pre-construction activities might result in discharges to to the waters of the state. Similarly, the pipeline is at a complete standstill. There are no activities going on. And as we pointed out in our brief, the environmental conditions 11 and 27 to the Ferc certificate order make clear that the company cannot engage in any construction or any ground disturbing activity prior to receiving authorization from the state. Now, the state in particular is the entity that has denied the necessary approvals for the pipeline. So we think that the state falls completely within the Delaware Department of Natural Resources case. That case is on all fours. It's from this court in 2009. And it's a situation where the state of Delaware denied a Coastal Zone Management Act authorization for an LNG terminal within its borders. So the same situation arises here, where the state has blocked the project that it does not want. So there's no standing to contest the merits of the Ferc certificate. I know that the state has said that there is special solicitude for the states, but in the Delaware Department of Natural Resources case at footnote 6, the court pointed out that the special solicitude does not eliminate a state petitioner's obligation to establish a concrete injury. And that's exactly the situation here. The state cannot establish a concrete injury where it itself has blocked the project from going forward.
You want to address the questions I raised with counsel about law of the case and our circuit position as to the binding nature of a decision by a motions panel in denying the motion to hold this case in abeyance?
But yes, Your Honor. I appreciate the question. I think it's important to remember that Pembina filed the motion for abeyance on the same day that the commission filed its merits brief in this case. The pipeline's pause was announced very, very soon before the commission's brief was due. So those filings happened on the same day. So the motion for abeyance was filed before the petitioner's reply briefs were filed. And of course, the motions panel did not have the benefit that the merits panel has of hearing oral argument and hearing these issues fleshed out.
Well, it could have. It could have said, we're going to wait to see what the reply brief says, and now we're going to hold oral argument. And it didn't. And the staff attorney memos fleshed out the issues, the harm that was being alleged, the use of judicial resources. And the panel, so far as I can tell, weighed those and decided, no, we should go forward and hear this case.
Well, Your Honor, I don't know what the panel was thinking, or I don't know its reasoning apart from its denial, but I will say that in the 6 to 8 months since the pipeline has announced its pause, it has done absolutely nothing to advance this pipeline. So that's something else that the court can take into account. The court, I believe, still could put this case into abeyance.
And Ms. Chu, am I wrong to note that the order that was issued previously by the motions panel did not include reasons? So notwithstanding what they were looking at, whatever they were looking at, if it's law of the case, it really is not binding us with respect to reasons regarding the holding it in abeyance, because no reasons were given. Is that correct?
That's correct, Your Honor. That's correct. I mean, I don't know the reasons because the order did not put forth the reasons for denying.
Well, that's an interesting legal theory, but when a 3-judge panel decides something and they say denied, another 3-judge panel can't just ignore that and say, well, you didn't provide enough explanation. They may go ahead and reach a different conclusion. But I think it's a serious jurisprudential matter here where our court has repeatedly said law of the case. And now, I mean, everybody spent a lot of time and energy preparing for this appeal. And nothing may have happened so far, but who knows? You know, tomorrow, 6 months from now, Oregon could say, well, we changed our minds. We think, you know, this ought to go forward. Where are we? I mean, I don't understand why all of this couldn't have been fleshed out before Ferc. Ferc is the expert in this area. It knows what its orders mean. It also knows what it means when the company says, when we determine this abeyance period is over, you know, that's not Ferc. That's what I'm concerned about here. And I'll stop expressing my frustration, but that is it. There are two. It's not only that I think there's a law of the case problem, but it's that we're trying to adjudicate this case like de novo on appeal. And yeah, I just don't think that's what we do.
I hear you, Your Honor. So Judge Rogers, I understand the concerns. I think the law of the case issue is just firmly within the court's discretion to adjudicate and decide that issue. As for adjudicating this case de novo, that's not what the commission is asking the court to do. I would say that this particular area of permitting of interstate natural gas pipelines is under serious examination at the commission. The commission—
I understand that, counsel, but we have to take what the commission did here. The
Right.
landowners have made their position very clear.
Understood,
They
yes.
can't use their property, that they're suffering loss of property values, all kinds of things. So the commission was well aware of this when it issued its certificate order. It was also aware of the state's concerns about what might happen, even though the certificate order barred the company from going forward without the permits. That's what I mean by we're sort of trying to think this case anew.
Well, Your Honor, sorry.
Go ahead.
Well, I think events kind of overtook the unfortunate issue. The unfortunate thing is the timing here. I mean, at the time the certificate order issued, it was the commission's understanding that the pipeline wanted to proceed with this project. That's, you know, this authorization was issued under that understanding, but it wasn't until April of 2021 or maybe February of 2021 that the pipeline started indicating that it might not be going forward. And by that time, this case was already pending before the court. That, you know, when the agency learned of this potential pause, the merits brief was already mostly drafted. So
well, I know, but counsel, nothing prevent anybody from moving to remand the case to the agency in light of changed circumstances.
I understand, Your Honor. I mean, that is something that I can certainly take back to the agency. In this particular case, you know, since we are sitting here now, I do think that the question is in the court's hands as to what to do, and I do think we lack an Article 3 case or controversy, and we lack a ripe case for review. I do want to highlight the Deborah case, which I understand the pipeline also relied on. That case,
the which case?
The Deborah versus NRC.
Yes, right. Yes.
Right. So that case involved the Nuclear Regulatory Commission's authorization of a nuclear waste facility on land belonging to the Skull Valley tribe.
Right.
And that's a case where the tribal petitioners actually argued that the 20-year license, it was a 20-year license that the NRC had granted. They argued it was ripe for review because even though 2 federal agencies had denied authorizations that the licensees needed to transport waste to the facility, despite these denials, according to petitioners, the companies could potentially find another way to transport nuclear waste to the facility that did not require these approvals. But the court rejected these arguments as too speculative to support review.
Do you agree here that the state denied the application for a permit without prejudice?
Yes, but that would, I mean, it would require the company reapplying to the state, and presumably since the state is a petitioner here, it is not going to be inclined to grant those permits. Moreover, at least if both of those were upheld, I mean, the state's denials, the state's denials under the Coastal Zone Management Act was upheld by the Secretary of Commerce. The federal government declined to override the state denial. And then the Clean Water Act, Section 401 authorization, I mean, that also was a situation where the pipeline petitioned the commission to find that the state had waived the 1-year deadline under the Clean Water Act, and the commission rejected the pipeline's petition. So these aren't just temporary, ephemeral denials. I mean, these are denials that have been upheld.
Can you, counsel, help me understand another aspect of the timing of this? My understanding from the papers is that it was that the pipeline's timeline for construction was 53 months. That it
I
would
think that's
take
right, Your Honor.
53 months to construct.
It was almost 5 years. That's right.
In that the certificate order expires, I believe, in March 2025, which is less than 53 months from now. But I'm assuming that Ferc has the discretion to extend the deadline so that if the pipeline, 6 months from now said, okay, we want to begin construction, and it does so, they're not going to make that deadline, that they can move for FERC to extend the deadline. Is that how that works?
Typically, yes, but I'm not sure, Your Honor. If this case is before the court has exclusive jurisdiction over the docket. I expect the agency would not be able to extend the deadline if, for example, this case were being held in abeyance. I think this is very reminiscent of the Atlantic Coast Pipeline and the Penn East Pipeline cases, which this court held in abeyance under actually more tentative circumstances. I mean, in those cases, the court held them in abeyance pending Supreme Court litigation that might have some bearing on the pipeline's ability to go forward. I mean, here we have definitive denials from the state, and also a pipeline commitment not to initiate eminent domain. So I think the circumstances are even stronger than Atlantic Coast Pipeline and Penn East, where this court held the cases in abeyance.
All right, thank you.
Thank you, Your Honor.
Any further questions? Thank you, counsel. So I guess, counsel for petitioners, you have a few minutes on reply.
Yes, Your Honor. Thank you. First of all, the state permit denials. First, the CZMA was without prejudice, and the 401, in fact, the state concluded, and in fact, FERC agreed that there was no actual application even ever made. So that's there are blank slate there, and the idea that the state is hostile, that the state's regulatory process is somehow skewed, is a very odd suggestion coming from a representative of a regulatory agency. The state, of course, will look at the record and the facts when they're presented to them. But more importantly, the Penn East case is an excellent example. After the 401 certificate was denied by the state of New Jersey, Penn East still started condemnation actions in the state of New Jersey. There is nothing to stop Pembina from starting condemnation actions this afternoon, or even while we're talking here. This case, so in terms of if there's some action by FERC or the court that absolutely takes away that ability, that's one thing. But without that ability being taken away, the fact that, well, they might not, is not good enough to deprive, it certainly doesn't deprive petitioners of their standing, which again was established when they filed the petitions. So the question is this case moot or is it not ripe? It is not moot because the FERC has not met its burden of showing the bad conduct can't happen again. We don't know that whether or not Pembina will condemn, and Pembina again refused to say that it would not, even if it canceled the project. So, and the case is right because unlike the Devia case, the court was very clear that there was no current harm to the petitioners in that case, and therefore they could put off deciding it to see what would ever happen. There is current harm here. FERC is trying to dance around it in so many ways. It is current harm is inflicted by a combination of FERC granting a certificate that they should not have granted, and Pembina refusing to say it will not exercise its rights under that certificate, starting possibly tomorrow, or even if it cancels the project. That's where the harm is coming from. Last one, obviously, eminent domain is not conditioned on anything, and as FERC concedes, there's nothing they can do to condition eminent domain. It is once that certificate is final. FERC's position is they can't do anything about eminent domain, except perhaps in the circumstances of while their rehearing process is going on. FERC has conceded that. They've passed an order saying that we will stay certificates so that eminent domain is stayed during the rehearing process. But after that, we have no authority to stay eminent domain. So the risk is real, and Pembina is refusing to do anything to make that risk go.
Mr. Brookbinder, let me just be clear. As far as you know, Pembina is refusing. We don't have a statement from Pembina in response to the gray briefs, your gray briefs, indication that certain conditions would be fine, right?
Pembina did file after we submitted our brief and FERC submitted theirs. Pembina filed a joinder in FERC's brief. Pembina certainly had the opportunity either to file its own brief. It simply said, us too.
So I'm sorry, let me be clear. And I understood in the gray brief, you're saying after you filed in July, a brief that assailed and this is outside of the context of the motion for abeyance. I thought there was some discussion of how the harm still exists because Pembina has the ability to continue to condemn beyond the life of the project, et cetera. And the suggestion being that if they did not have such authority, then you wouldn't have the harm and you'd be fine with that. You're saying Pembina indicated at some point after your briefing in this case that it was sticking by any previous representations about retaining its eminent domain authority under these circumstances.
No, not quite, Your Honor. What I'm saying is that Pembina filed a joinder into FERC's merits brief. They didn't, which said nothing about them doing anything about eminent domain. They just said FERC's arguments are fine by us. We join in them. Thereafter, we filed a reply brief, which had all of the discussion in response to FERC's standing argument. But Pembina was perfectly free to file something at that point to say, hold on a second, or to contact landowners and say, let's put this case on the shelf. We've heard nothing from Pembina. That is all except for one last thing. FERC is very free with extensions. Our brief contains lots of examples where FERC is handing out extensions on a permit on deadline to be in operation, including cases where it's the second or third or fourth extension. They just always extend requests, but they can't do that. As a matter of fact, I agree with counsel for FERC. They may not do that while this case is, after they filed the record in the case with the court, they have no jurisdiction over that certificate. They cannot, they cannot extend it. They cannot stay it. They have no jurisdiction over it. The only one who has jurisdiction over that certificate is this court.
All right, thank you, counsel. We will take the justiciability issues under advisement And we will move on to issues related to purpose and benefits. Counsel for petitioners.
Yes, Your Honor, thank you. Getting to the merits of this case. This is truly the most absurd project FERC has ever greenlighted. The purpose of this project, or the concern of petitioners, is FERC says it's okay for Pembina to take their property in order to ship Canadian gas from a terminal that actually has no customers. And this leads to 4 separate grounds that this court can vacate the certificate.
Just so that I'm clear, you're calling it Canadian gas because the company that owns the gas is the parent is a Canadian, but the gas would physically originate in Oregon, right?
The gas would physically originate in Canada, would come down the GMT pipeline from Canada, and then would enter the Pacific Connector pipeline. The source of the gas is Canada. There are expert reports in the record that we submitted that FERC never mentioned or responded to, saying essentially because Canadian gas is cheaper, Canadian gas is economically what will be used, plus the fact that Pembina is a Canadian corporation in the business of processing and transporting gas. It also makes sense for them to want to source the gas from Canada. In fact, they applied to Canada for permission to export 100% of the gas they would need for this project, and they applied to the Department of Energy for permission to import 100% of the gas that they need for this project. They have those permits. They were very clear to the Canadian government. The Canadian government said, hold on a second, how do we know you're really going to be doing this? And they said, we intend to do everything possible to meet all of our needs for Jordan Cove from Canadian gas.
So, Mr. Bookbinder, I just want to be clear because I think I was not as focused as I needed to be in my preparation on this particular point. You're saying the gas originates in Canada, comes through some other pipeline, links up with this disputed pipeline, and then is exported back to Canada?
No, exported, we assume, and Pembina's business plan is to export to the Far East.
Oh, to the Far East.
Yes, ma'am.
I see. So it starts in Canada, but eventually goes somewhere, but not in the US. It never ultimately resides in the US. Is that correct?
FERC concedes that not one molecule of this gas will ever be used by any American consumer. All of it, 100% of the gas of this project is destined for export, and the record evidence is solely that this gas will come from Canada. And FERC has abandoned the idea that it, quote, will carry American gas. And in the Coastal Zone Management Act appeal to the Secretary of Interior said, hold on a second, we want to know something about this project. What gas is going to be carried in this pipeline? Is it going to carry any American gas? And FERC said, we have no way of knowing that it'll ever carry American gas. In fact, that is a question we do not ask. But we gave them the answer. We gave expert reports. And the fact that Pembina has applied for and received permission from both Canada and the United States to supply 100% of the project's needs from Canada. That's why they're taking Americans' property to ship Canadian gas to the Far East.
All right, so what is the import of that set of facts in terms of your legal argument? Are you then suggesting that Section 7 is not properly invoked? This is not an interstate commerce issue, or what do we do with that information?
There are 4 grounds, Your Honor. The first is, since you've raised the interstate issue, we'll jump to those issues, which are, as this court said in Oberlin, there are 2 questions we have about whether exported gas qualifies, or pipeline for exported gas qualifies to get a Section 7 certificate. And the 2 grounds were, 1, the law of the District of Columbia Circuit is that exports are not in interstate commerce. And that was first decided in the border pipeline case in 1947. It was reaffirmed in the District Gas case in 1974. District Gas noting that between Borderline and the time they wrote their opinion, the Federal Power Administration, FERC's predecessor, asked Congress 14 times to overrule border pipeline, and Congress didn't do so. And What this court did in Oberlin was to say, Ferc, you haven't explained, the petitioners have said that this is not an interstate commerce. Can you please explain it? They failed to explain that. The Oberlin remand, the decision of this course, remanding it back to Ferc came long before Ferc issued the certificate, and we were busy quoting and citing Oberlin all over the place and saying, can you explain how this is somehow an interstate commerce? And Ferc has only a single explanation, which is, well, some of the gas could come from the United States, and therefore it's an interstate commerce. That's it.
The fact that the pipeline travels over states, that the gas is transported through various states, as opposed to other cases in which the gas might be sourced, say, from Texas and go right over to Mexico, and so there's no other states. You're saying that's not enough.
In Oberlin, the gas was very clearly, the gas was produced in Ohio, crossing the border into Michigan, and then would be exported to Canada. That did not phase the court.
Did the court in Oberlin send it back on that ground? I thought the court in Oberlin was focused on the public benefit or the public, both.
Both. Those are two separate grounds in Oberlin.
Okay.
And the border pipeline case, where I believe, yes, the gas all originated in Texas, and that was precisely because of that. Because it was intrastate gas that FERC did not have jurisdiction over, they said, okay, we have jurisdiction over this because it's being exported under Section 7. We have jurisdiction under Section 7 because it's being exported. Regardless of the fact that it's intrastate gas, we can't regulate it because of that, but we can regulate it under Section 7 because it's exported. And the border pipeline case said, no, Section 7 does not cover exports.
But border pipeline did not involve travel over multiple states. So what do you do with that factor in terms of your interstate commerce analysis?
We looked to the Oberlin decision, which said we have gas here moving from Ohio into Michigan and then exported. Can you please explain to us why this is an interstate commerce? And it simply isn't. I mean, border pipeline, they literally did not say a word about the fact that this, neither the court didn't say a single word about the fact that this stuff is all being produced in Texas. They said, yes, it's being produced in Texas, but FERC is trying to claim Section 7 jurisdiction because it's exported. That's
all
where.
Right. So can you move to the next? I think we have that point. You said there were 4 different.
Yes. Well, the Oberlin gives us a second basis for vacatur, and that has to do with whether or not exports produce public benefits. And let's start with the Natural Gas Act itself. Section 1 of the Natural Gas says it is declared that the business of transporting and selling natural gas for ultimate distribution to the public is affected with a public interest. And more specifically, in 1947, when Congress amended the natural gas to add an eminent domain provision, the problem that Congress addressed was state A was producing the gas. They wanted to send it to state C, but state B in the middle wouldn't give them, there was no public use under state law such that they could grant eminent domain authority. That was the problem. And the Congress was very clear in the Senate report 429 in the 80th Congress on page 2, very clear, the operation of the pipeline would not be for the benefit of the public in those states crossed by the pipeline, but in which there's no distribution of natural gas by such line. If there's no—
Mr. Bookbinder, that sort of line of reasoning seems to cut against the sort of statutory, clear interest of Congress in authorizing exports of gas. My understanding was that the statute, maybe it's in Section 3, I'm not exactly sure, but there is a stated congressional interest in promoting exportation. So if the holding is as broad as long as this gas is being exported, there can't be a public benefit, I'm wondering how you reconcile that with Congress's interest in exporting this kind of product.
2 answers to that, Your Honor. First is that very first sentence in the Natural Gas Act that I just quoted, after it says there's a public interest in distributing natural gas to consumers in the United States, it goes, and there's a public interest in regulating that interstate and foreign and exported gas. There's a public interest in regulating both kinds, but the public interest is in specifically the distribution of gas. And more importantly, is it public interest? Section 7, the Section 7 deals with the interstate gas, and the reason why exports don't have any, do not provide public benefits. And Ferc says that, let me give you the laundry list of Ferc's reasons for why there are public benefits, which is, well, they said, first there'll be distribution of gas. And then they realized on rehearing that there was no distribution of gas. Then they said, well, this will increase production of gas. And we cite two things. One, that Ferc's repeated statement in every LNG export terminal case saying, we do not see any basis for saying that an LNG terminal will increase production of natural gas. And our brief is chock full of quotes from Ferc's findings in every other LNG terminal case. We have no evidence of any increase in production from LNG terminals. And
Mr. Brooklinder, I'm sorry, I'm mindful of your time and I want to make sure I get in a couple of quick questions. I did find the section that I was talking about. Section 3C of the National Gas Act indicates that exportation and importation shall be deemed to be consistent with the public interest. So I'm trying to understand why your argument, first of all, is not, how is it consistent to suggest that an export pipeline is not a public benefit, given this statement in the law? That's point one. And then point two, I understood City of Oberlin, which you're relying on heavily for making this argument, is on remand after the courts sending it back, and is currently being litigated in this court after that remand. So to Judge Rogers' very good points about process, why shouldn't we be waiting to see what the City of Oberlin folks panel, whatever that panel is going to be, says about this issue?
Because, Your Honor, the issue in Oberlin, first of all, Ferc says even without the exported gas, we don't even need to include the exported gas. Take it out of the equation, we still are justified in issuing a certificate for public convenience and necessity.
I understand, but it was sent back on this question. Ferc has now filed, my understanding is, in that case, an extensive discussion of this very issue, the interaction between export pipelines and the public interest, and whether or not we can take into account in this case that statement will be considered by a panel of this court in the context of that pending case. So under what circumstance should we go forward now and be making any pronouncements about this particular issue?
Okay, two reasons, Your Honor. First of all, that the export issue is an alternative argument that Ferc puts forward. Ferc says that the court never needs to get to the export argument.
In Oberlin.
Yes, they say that very clearly. We can justify it. The pipeline carried gas both for export and domestic use. And Ferc says, just on the basis of the gas for domestic use, that justifies the pipeline. So we may never get to the point in Oberlin of this issue being decided. But more importantly, the issue in Oberlin, the issue may come down to, look, only some of the gas was being used here. That's really not an export pipeline. We have a pipeline where 100% of the gas is going for export. And as a policy matter, there are at least six LNG terminals in Ferc's, forgive the word, in Ferc's pipeline now. They're going to be applying for permits to build pipelines to feed them. And we don't want the landowners down there, they don't want to wait to find out whether or not pipelines servicing LNG facilities specifically get eminent domain or not. And it will be years before any of those cases reach that court, during which their property will be taken and destroyed. This is the court's opportunity to reach the issue of, is a pipeline supplying an LNG facility? Does that get eminent domain?
Can I just ask a factual question to make sure I understand something? Is this pipeline that's the subject of this certificate order that we are reviewing, is it physically resident in any state other than Oregon, or does it begin in Oregon and end in Oregon?
Yes, Your Honor, begins it at a interconnection with the GMT pipeline in Eastern Oregon, and then would be built over to the coast of Oregon.
And so part of the FERC's rationale is that because the pipeline interconnects with these other pipelines that bring gas from other states, this is an interstate project, right? That's part of FERC's rationale.
Yes, Your Honor.
But as you point out, there are no precedent agreements from any of those other pipelines or anyone else to demonstrate that the gas will actually be used from any other state. The only agreements we have are with respect to the Canadian gas, as you call it, right?
Not quite, Your Honor. The precedent agreement that FERC relied on is not between the pipeline and any gas coming into it. It's between the pipeline and its sister company, the LNG terminal.
That owns the terminal, that's right.
Right.
Yes.
There's no commitment as to gas. And all FERC is saying is, well, it's part of a, it's plugged into other pipelines that are plugged into other pipelines. If that suffices to bring it within interstate commerce, then there are 300,000 miles of interstate pipeline in the United States, virtually any pipeline.
So if I understand your argument, there are at least 4 strikes against this project, just kind of from the kind of interstate jurisdictional public benefit analysis. One is that there's not a precedent agreement with any gas supply for this. The only precedent agreement is with the terminal that would accept the gas from the pipeline. B, there's no precedent agreement with any gas supply from another state. So it's not really an interstate pipeline in that sense. It's just presumably going to get gas from an interconnect that originates in Canada, which leads to strike 3, which is that it's not even a pipeline to serve US produced gas, but Canadian gas. And then strike 4 is that all of the gas will be exported, and so none of it will be used in the US. And so we have a situation where, other than kind of the argument about ancillary economic benefits within the US, jobs, et cetera, FERC is essentially kind of approving this and delegating taking authority for this private venture to be able to take private landowners' land and kind of its supremacy clause authority to take state land for this pipeline. At least those 4 strikes against it, right?
Yes, and there are a couple more, Your Honor, just on that issue alone. The pipeline, FERC denied this same project in 2016, saying the pipeline had no contracts at all. So what Jordan Cove did, the pipeline then signed a contract with its sister company, the terminal. The terminal has no customers. After 8 years, they have to report, because they have DOE's Section 3 authorization to export gas, and they have to report to DOE every 6 months, what is their status of contracts to actually ship gas? And every 6 months for 8 years, they've said, we don't have any such contracts. So,
all right, but what is the I understand that, but isn't FERC's point that it ordinarily doesn't evaluate public convenience and necessity on the basis of the end user and evaluating the extent to which the gas is going somewhere or whatnot. That it, as far as it's concerned, as long as there is a contract or series of contracts that covers the capacity and that is lawful, binding, there it is, that's good enough. I mean, are you suggesting that Jordan Cove is not a customer, that there's something wrong with the contracts that it entered in this case? They're not enforceable agreements to buy the 90-some-odd% of gas?
Your Honor, I would refer you to our 28J letter dealing with the case only decided a few months ago by this court, Environmental Defense Fund versus Ferc, where the court vacated a permit for a functioning pipeline on the grounds that it relied on a single affiliate contract that was signed after it couldn't find any other customers.
And wasn't there also some self-dealing in that case? Wasn't that the key?
No, it was a single affiliate contract signed after they couldn't find any other customers, and there was no new demand for the gas, that their existing system met it all. And there was a ton of evidence on the other side that there's no new demand for this gas. Why are you doing this? We have something even worse. We have a single affiliate contract signed after FERC denied it on the grounds you don't have any contracts, where there's no demand for the gas.
But didn't FERC also make a statement that it had found no indicia of self-dealing? So let me just home in on that. That seemed to be different than what this court found significant in the case that you mentioned. So is there some evidence of self-dealing in this case? And if so, what is it?
No, Your Honor.
Companies, and just because they're affiliates doesn't mean we have self-dealing, right?
No, that is correct, Your Honor. It's all the other factors that point right at this being something that FERC should not have approved. Again, as I ran through the other factors that the court looked at, the project was rejected because it had no contracts. It quickly signed a contract with its own affiliate, and here we have that the affiliate in the EDF case at least had customers. It was a gas company; it could sell the gas. This is a contract with an LNG terminal that has no customers.
But it did pre-exist, right? It wasn't like that other case. I'm bad with case names, so I mean, it wasn't like the case in which it was created for this purpose, right?
No, it was not created for this purpose. This is a single project. The LNG terminal and the pipeline are a single project, and the idea that they would ship gas, their terminal has no customers. You could build a pipeline. They could exercise eminent domain for a pipeline that, if built, would go to a place that has no use for the gas. It's a complete dead end. It's a pipeline to nowhere.
Well, we don't know that it doesn't have. FERC says we don't have to look at where it's going ultimately in this sense, right? We don't know what's going to happen to it.
No, that's not quite, Your Honor. They said we don't care where it goes, but the terminal has said every 6 months, the Department of Energy, most recently on the 1st of this month, no contracts. We have no market for this gas. So there can't be market demand.
All right, so Mr. Bookbinder, what's the remedy? Are you saying that the entire certificate has to be canceled on this basis, or that FERC needs to look into more to determine these factors? It has to care, and it has to investigate, and it has to say something about where it's going and whatnot.
Your Honor, vacatur is, as I said, there are 4 separate grounds for vacatur. And the first one is that that the same grounds has existed in EDF versus Spire. There's no demand. It was this single affiliate contract, et cetera, et cetera. Secondly, in EDF versus FERC, the court said, look, you balanced the harms of the project, the adverse impacts, against the supposed benefits in a single conclusory statement. And that's exactly what they did in this case. And our 28J quotes the language in that case and points out what FERC said in this case. It is the exact same ipsa dixit, a statement without any sort of analysis or stuff. saying, here are some benefits, and we know some bad things will happen, and we find the benefits outweigh the bad things. And that's all they did. And that the EDF court said was a separate ground for vacatur itself. But then we get to the interstate nature of the pipeline, and then the export pipeline, and the fact the benefits, the general economic benefits themselves are not cognizable under the Natural Gas Act. That's, the idea that there's general economic benefits. The Natural Gas Act was not passed as a Jobs Act. And what you say about general economic benefits goes for any infrastructure project. And
just cut to the chase because of time. I think if I understood Judge Jackson's question correctly, it's the same one that I had, which is that, are you saying that we should vacate the certificate order and remand, and FERC can kind of reconsider whether to grant the certificate, or whether we vacate and say that on this record, there is no kind of set of circumstances where FERC could reasonably grant the certificate? And we say that so that essentially for the pipeline to get a certificate, they would have to like start over. They couldn't just ask FERC to kind of reconsider on remand. And if you're asking for the latter, what's your authority for us doing that? But maybe that's not Judge Jackson's question. That's
part of my question. I mean, that was part of my question. There's a third option, which is remanding without vacatur, that we just remand to say you haven't explained enough about what it is that motivated your view of the need for this pipeline or the export circumstances or whatever. So can you respond to Judge Wilkins?
Yes, the vacatur is, I'm going to accept it. I'm going to say vacatur is warranted, whether that you remand it or not to FERC. Vacatur is completely warranted here. There's no possibility of a public benefit. The record is very clear that the only economic benefits from this pipeline would accrue from constructing it. There's no distribution of gas. There's no increased production. The production all comes from Canada. And what Chairman Glick said, FERC said, well, we're building transportation capacity. That's a benefit. And Chairman Glick said, it's a matter of fact, in the remand decision of the Oberlin case, where they advanced the exact same rationale, he said, if the benefit of new pipeline capacity is that it will provide new pipeline capacity, then the commission's assessment of need is little more than a circular check the box exercise. And that's in his dissent in the Oberlin remand decision. And it also, so there's literally no benefit from a project that has no customers, no possibility of customers, being supplied entirely with Canadian gas. The only benefit that will be recognized is let's buy some people's property, tear it up, build a pipeline. That's it. That's the only possible scenario. And we're going to get some jobs out of this. And that's a general economic benefit. And as a result, this certificate is justified. That is not. If I don't think that this can be rehabilitated, but if you remand it to FERC, if you vacate it, so the threat to landowners is gone, and remand it to FERC, I can understand why the court would go in that direction. I don't believe that's warranted because this record is so clear that this is a utterly absurd project. But vacating and remanding is also something that we would, the landowners would be very happy with that result. They can breathe a little bit easier.
All right, why don't we hear from counsel for FERC?
Thank you, Your Honor. I think that there are at least three aspects of this particular issue that need to be clarified. So if the court will entertain it, I think the three issues are, first, the factual interstate issue. I mean, this is an interstate gas pipeline that is transporting gas out of the Rocky Mountain region to Oregon. The second is the kind of statutory issue that Judge Jackson was bringing up between Section 3 and Section 7, and how the commission, it does the analysis under Section 3 informs the commission's determinations under Section 7. And the third is the impact of the recent cases on this particular case. That would be the impact of Oberlin and of the Environmental Defense Fund's fire case. So let me start with the first issue, the Canadian gas issue. The commission has not ever conceded and does not now concede that this pipeline is solely to transport Canadian gas. The record is clear that the commission was finding that this pipeline, the Pacific Connector pipeline, is designed to transport gas either from or both from Western Canada and also from the Rocky Mountain production area. In the rehearing order, paragraph 41.
Is all of that within Oregon?
The pipeline itself is within Oregon, but it
No, the Rocky Mountain.
Oh, no, sorry. No, it's not.
Where is
like Wyoming, Colorado, the Rocky Mountain production area.
and the record is clear on that?
Yes.
So I read Ferc to be referring, and maybe I misread, to the fact that bringing this, what we're calling Canadian gas, would, among other things, provide, what shall I say, gas that could be used within the United States. And you couldn't tell necessarily whether it was going to be Colorado gas or Canadian gas that's used on Project X, but that ultimately, whatever the volume that came from Canada, that same volume was going to be exported, but the gas itself might be a mixture or not. Was that Ferc's thinking?
I think that's right, Your Honor. I want to make sure I understand what you're saying. I mean, as
in other words,
know,
it's not that there's a straight line from Canada to the Far East.
Right. That's right, Your Honor. Right. You can't trace a particular gas molecule in a straight line from Canada to the Far East, or from the Rocky Mountain production area to the Far East, for that matter. Once the gas molecules go into the pipeline system, all of these molecules are fungible, and you can't tag one or two of them to determine exactly where it goes.
But you don't dispute that was never any precedent agreement with this pipeline and any supply from the Rocky Mountain region, right?
That's technically right, Your Honor, but there was a precedent agreement for 96% of the pipeline's capacity. Here, the terminal has committed in a binding agreement, as Judge Jackson pointed out, a binding enforceable agreement that it will be using 96% of capacity.
But you're making the argument that this pipeline has the capability of receiving gas from the Rocky Mountain region.
Yes.
But there's nothing in the record saying that anyone with that gas wants to use this pipeline for that purpose.
Oh, now actually, Your Honor, in the authorization order, paragraph 85, JA 37, the commission describes benefits to Rocky Mountain gas producers, and it quotes some comments by a gas producer in Western Colorado saying that it would benefit from having the pipeline capacity available and that it could access additional markets because of this pipeline. So there is record evidence supporting the Rocky Mountain production, the benefits to the Rocky Mountain production area. I also want to clarify that the Pacific Connector did hold an open season for this pipeline capacity, and it did receive another competitive bid for the capacity. It did reject that bid, It found the bid was not creditworthy and it instead chose the Jordan Cove bid. But the bidder did challenge that rejection, and that's all described in the authorization order at paragraph 66 to 80. That's at JA 28 to 34. So there is evidence of demand for this pipeline capacity. I also want to just clarify, to make sure we're all on the same page, that the demand for the terminal is not before the court. That was decided by the Department of Energy, and it determined that exports to the Far East, that pipeline exports were in the national interest, that they would produce domestic benefits, or that they were not inconsistent with the public interest under Natural Gas Act Section 3.
So
that's not challenged by the petitioners. It's just the pipeline that's at issue.
Right. And let me try to understand, because it felt a little bit, in my view, under these circumstances, like FERC was sort of throwing up its hands in a particular way. And that is that it says, the domestic benefits. I guess I'm trying to understand, for the purpose of Section 7, does there need to be a showing of domestic or foreign benefit in terms of market need? And if so, what showing was made in this situation? I feel like FERC is saying there's really no need to evaluate domestic need because the gas is going to be exported. And we don't evaluate foreign need because that's in the bailiwick of DOE under Section 3, sort of in the same line of what you were just saying. We're not focused on what's going to happen at the terminal from then on. So what is the public benefit that is accruing from the construction and operation of this pipeline that is going to ultimately export the gas?
Thanks, Your Honor. I think I understand the question conceptually. I guess one logistical background point is that the gas exports have been approved by Department of Energy. They're originating from this terminal at Jordan Cove. Now, without the pipeline, that terminal can't function. So I think that is important background for how Sections 3 and Section 7 of the Natural Gas Act interrelate. The commission here said that Department of Energy has made this public interest finding under Section 3, and that finding informs the commission's determination under Section 7 that the pipeline is required by the present or future public convenience and necessity. Now, while the Department of Energy's decision is not dispositive, if you consider it as a whole, if the commission were precluded from considering the Section 3 authorization in making its Section 7 determination, that would eviscerate Congress's intent in Section 3.
Right. So can I just say, I'm not saying you're precluded. It's a factor. You can consider it. Mm-hmm. But how does that interact with Section 7's requirement of some evaluation of what I understood to be domestic public need? Maybe I'm wrong about that, so you can address, as evaluated by market demand. So fine, you can take into account the DOE's assessment that this is going to be exported, all that's fine, but does that totally then eradicate any other considerations about domestic need or benefit?
Okay, got it, Your Honor. No, it does not. So the commission here made specific findings of domestic benefits, and they're in two categories. One is kind of the broader set of domestic benefits, and that's primarily at rehearing order paragraphs 40 through 42, JA 225. And that's where the commission discusses how transportation service generally provides public benefits. It helps develop the gas market, adds transportation options for producers, shippers, consumers, strengthens the economy, supports domestic jobs. And the commission also talked about how gas markets are dynamic with supply and demand fluctuating locally and regionally on a constant basis. And of course, we have seen very recently how these fluctuations in response to the pandemic, in response to extreme weather, like how these fluctuations affect everyone globally and here in this country. So the commission has all of this in mind. Now, more specific to this case, the commission did find that this particular pipeline would provide additional capacity to transport gas out of the Rocky Mountain region. So that's at authorization order paragraph 85, JA 37, where the commission is quoting that gas producer from Colorado, and also where the commission is quoting an applicant's statement that they cannot meet the gas supply needs of the Jordan Cove terminal without accessing Rocky Mountain supplies through the Ruby Mountain pipeline. It's possible that the applicant would have, it would respond to fluctuations in market prices and changes in supply and demand. And there may be times when the gas is supplied, it's coming from Canada, but it is also true that the commission found that the Rocky Mountain production region in the United States would receive benefits from this particular pipeline.
All right. And you're saying the commission doesn't have to focus on market need in the form of domestic usage of the gas?
Yes, that's right, Your Honor. Certainly domestic usage would be a benefit to the public here. But I think because of Section 3 and because of Congress's determination in Section 1 that, as Mr. Bookbinder was pointing out, that the transportation of natural gas and the sale of natural gas in interstate and foreign commerce is necessary in a public interest, like that forms part of the commission's need analysis.
All right, so is this getting into your second, you had 3 issues, the Section 3 versus Section 7 was the next one. Can we?
That's right, Your Honor.
Yes.
Yes, and I think that's where I want to make clear that the commission isn't saying that the Department of Energy's determination is dispositive of the Section 7 issue. Like, that's not the commission's position, but it does inform the agency's conclusions. And as to these factors, as to how the commission considers like what goes into this public benefits analysis, that's a matter uniquely within the commission's expertise and knowledge, and it should be granted Chevron deference in how it administers the Section 7 pipeline determination.
All right, so moving to Mr. Bookbinder says, and your third point is about the impact of the recent cases. He points to cases that he says indicate that it is the law of this circuit that a single precedent agreement with an affiliated company is not going to cut it for the demonstration of the need for the pipeline. Why is he wrong about that?
I think Mr. Bookbinder is overly relying on the Environmental Defense Fund case and taking that out of context a bit. I think Judge Jackson, as you pointed out, the Environmental Defense Fund case did turn on the fact that the petitioners there specifically identified plausible evidence of self-dealing, according to the court. And the court found that the commission had failed to address that evidence of self-dealing. So that was also a very different kind of contract. It was a precedent agreement between a pipeline and an affiliate that had captive retail customers. It wasn't this case, which involves, of course, an export terminal and a pipeline supplying that terminal. And also, the other case, City of Oberlin, is also instructive because the court in Oberlin found that the commission could put precedent agreements with affiliates on the same footing as non-affiliate precedent agreements, so long as there's no evidence of self-dealing. So that's the situation here.
But what about in Oberlin, a lot of the precedent agreements were for domestic use. What about precedent agreements with a single affiliate that are destined for export? I mean, aren't we in yet another category that isn't quite Oberlin or EDF because of that?
Maybe, Your Honor, that's possible. Right. So it is a precedent agreement with a single company that is affiliated. But I mean, let's just take a step back and look at this logistically. This pipeline is carrying gas interstate, and I think there's no real dispute that this is an interstate pipeline. If I can just back up just to Maryland versus Louisiana, 451 US 725. Gas crossing a state at any stage of its movement to the ultimate consumer is an interstate commerce during the entire journey. That was cited by the Commission in its authorization order, paragraph 48, JA 20. So here we have the gas being transported interstate within the United States. This precedent agreement is for transportation within the United States entirely. The gas is being carried over the pipeline. It's going to a terminal where it stops. It's being liquefied at the terminal. It's being stored and then loaded onto LNG cargo ships to be carried elsewhere. But these are interstate this is an interstate transportation of gas that is entirely within the United States, which is different from the precedent agreements in Oberlin, where they were actually agreements to bring the gas off the Nexus pipeline to, I believe, Canada. So it's just a very different set of circumstances, different kind of pipeline logistically and different kind of precedent agreement. But in any event, this is all the gas here is all interstate before it reaches this terminal for eventual export. And as you pointed out, Judge Jackson.
The distinction that you're making with City of Oberlin, was that made by the commission, or is this something you are making now in your brief in that argument?
I'm not sure to what degree it was in the commission order. To be honest, Your Honor, we certainly discussed Oberlin in the orders on review, but I think I'm just trying to draw the factual distinction for Your Honor's background purposes. I would like to say the one other thing. Mr. Bookbinder focuses on border pipeline, and I think that case is completely inapposite. I think it would not be reasonable to hold that a pipeline that's a 230-mile pipeline that's carrying gas that's originating from outside of Oregon and is transporting gas within the United States is somehow a Section 3 export pipeline. I'm not sure the petitioners made a clear argument that this pipeline should be authorized under Section 3 rather than Section 7, but the commission did explain that although it does authorize border crossing pipelines under Section 3, these are typically facilities that are just several hundred feet of pipeline, like extending from a border to a meter. Like that's not what we have here. We have a 230-mile pipeline that's bringing gas from different states to a point in Oregon. The fact that it is.
Can I just quickly ask you, because part of the standard of review here is for us to think about whether FERC has said enough in its orders to actually justify this pipeline. And you've said a lot of things here today that seem slightly different or more fulsome than what FERC actually says in its order. And so I'm wondering whether we should send it back for a more comprehensive, at least a more comprehensive explanation So for example, when I look at what Ferc says in the City of Oberlin pending remand brief, when they talk about exportation and the Section 3, Section 7 intersection, there's a lot more there than in this particular case. And when you pointed to paragraph 40 on JA 225, it just sort of seems like a boilerplate discussion of domestic benefits without really drilling down on things like you just indicated, which is, if this is ending at a terminal and it's being liquefied and it's being put on ships, there will be jobs because of that set of circumstances that would not have otherwise existed or whatever. Ferc doesn't seem to really give us the details about the domestic benefits in the way that you have. So why shouldn't we send it back for that?
Well, Your Honor, I think it's certainly within the court's discretion to send us back for additional explanation if it believes that's appropriate. I do think that the commission did provide this explanation. I think it's not just paragraph 40. It's paragraphs 40 through 42, at least paragraphs 40 to 42, and perhaps also authorization order paragraph 85, JA 37. I think it's all there in the orders.
I wonder too whether or not it's appropriate for us to consider the discussion that went on in connection with the EIS and the final EIS.
I'm sorry, what, Judge Rogers, which discussion are you referring to?
I'm referring to the discussion in terms of the issues that were presented to the commission, how it responded in adopting the final EIS.
If that's outside of the
response to
request.
Judge Jackson's question, I agree with your citation to those additional paragraphs, and I think there's more. But I also wonder, and I just don't know the answer, when we look at the certificate order and the rehearing order, when they reference the final EIS, is it appropriate for the court to take into account also the discussion, response, explanation that went on during that process as well?
Oh, yes.
We're looking for detail.
Yes. Yes, Your Honor. Yes, if you're looking for detail, absolutely. Yes, I mean, the references to the final EIS and any discussion in the final EIS, like, of course, that is, I think all the details are in the orders and in the record.
And I gather some of the petitioners' objections here, for example, are to the 15 years of suffering and the continued suffering that the landowners experience. And Ferc responds by saying, we've adopted this approach. And this approach focuses on the environmental harms or the economic harms, not individual landowner, quote, harms, which Ferc acknowledges exist here, while noting that there were negotiations between landowners and the pipeline about location and mitigation, et cetera. So what I'm getting at, we have cases that say if the path of the commission or the path of the agency is clear, that's enough. In other cases, we say, no, we want more of an explanation. And we've remanded for Ferc. Here, there are some summary statements, but they follow paragraphs going into more detail. And I'm wondering how you see this case as between where we have fulsome explanation going on for, paragraph after paragraph after paragraph after paragraph, And FERC uses words that courts like as distinct from what I'll describe as regulatory terms that are sufficient in and of themselves under our standard of review. And where do you see this coming or falling?
Well, I think the Commission's explanations are adequate. They're sufficient in this case to support its findings of a need for the project. And I think that, it's clear from the record evidence and from the Commission's explanations that this is a pipeline that does have market need. I mean, there was this other competitive bid for the.
Let me just
pipeline.
cut here. What I understand the landowners to be saying is FERC never took into account the harms we're suffering. All right. And what I see FERC saying in part, this is my view, not the way FERC exactly said it, is we acknowledge that there are harms. All right. Building this project itself contemplates harms, no matter where we put it. And so the pipeline has negotiated with landowners, come up with these mitigation measures, and given what our task is, we have addressed both the environmental and the economic issues. And that's our mission under our authorization statute as to what we're doing. It is not to provide what I'll call this sort of, it's easy to speak of it this way, like a compensatory relief to landowners who are suffering harms. So when I read the landowners' brief, that's what they say. It's inadequate. But FERC says, certainly it's not inadequate as to the environmental, although we'll get to the greenhouse gas in another moment, but that they don't have to address, Mr. Brown's concern he can't plant trees. Mrs. Jones is concerned she can't sell her property and a loss of value. That's not within FERC's responsibility as FERC has defined it and this court has affirmed. So I'm just trying to understand what you understand the deficiency that the landowners raise, because when I read their brief, it's fairly short. And they say two things: harms to landowners and the environment, and inadequate. And I think if you read these things, there's so much about the environment, whether you agree with FERC or not, they did discuss it. But they don't talk individually about these individual landowner harms. They just acknowledge that they exist.
Right. So I think I understand the concern here. I mean, the commission does consider landowner harms, potential landowner harms, as part of the economic test under its certificate policy statement. Of course, the certificate policy statement itself is under review at the commission, and the commission may decide to alter the statement.
I understand, but we're stuck with the one
yes,
that existed here.
Yes,
And
so it factored in. It did factor into the commission's decision making, and that was in the step one, the balancing of adverse impacts against public benefits. And the commission did find, as Judge Rogers, I think you alluded to, it did find at paragraph 89 of the authorization order, for example, JA 40, that the pipeline engaged in public outreach, it worked with stakeholders, and they developed reroutes where appropriate to minimize impacts on landowners. So that all factored into the commission's decision making. Now, as to the specific concerns that individual landowners have about planting nut trees in a particular location, or these specific desires that the landowners have for their properties, I don't think that's for the commission to adjudicate.
that's what I'm getting at here.
Right.
In other words, to the extent they acknowledge these harms, it's in the record. Most in the consideration of the final EIS. But on a remand, I just wonder what would FERC say? Literally. I mean, it understands that, and I totally emphasize with landowners who see their property values decreasing and their lifelong dreams destroyed. All right, don't get me wrong. But given what FERC's mission is under the statute, FERC doesn't have the authority to provide the type of relief they apparently want, other than seeking to have either FERC or the court set aside the authorization.
I think that's right, Your Honor. I think as part of the EIS process, the commission can always work and it can direct pipeline reroutes, which it frequently does. It does frequently direct pipelines to reroute around certain landowners' property if there's a specific concern. So there is that that forum. There's that option before the agency. But as to the specific eminent domain, of course, you know, in an eminent domain case, that happens in district court, state court, and that's outside the purview of the agency. So yes, the agency has certain authorities, and it can order a reroute, but beyond that, you know, it can't, as you were pointing out, Judge Rogers, you know, it can't direct that landowners be compensated the difference between fair market value and assessed value, for example. Like that's not within the agency's power.
So I don't want to redo this part, but one of the things I wondered is, suppose under the current certificate order, and given the concerns that the landowners have, suppose the project owner decides to exercise eminent domain on property it doesn't own. Can the landowner go to the commission and seek an order adjudicating that the project owner is in contempt, well, not contempt, but violating the certificate order, and get some relief that way?
I just want to make sure I understand. So in your
Well, I'm trying to
question,
understand here, assume, for purposes of my question, the project owner says, as long as we hold this in abeyance, you know, we're not going to exercise eminent domain. 3 months from now, the project owner goes back to Oregon. Oregon grants it the permit. Everything's looking great. And so the project owner exercises eminent domain. Could a landowner at that point go back to the commission and say, I don't know what the process is, and I'm really asking you, or would they have to come to court and ask the court, I guess in the district court, to find that there's been a violation of the certificate order? I mean, I assume you go back to FERC first, just for exhaustion purposes, but is there any process that's available there?
I think there is process available, Your Honor. I don't think this situation has ever arisen before. But I think what would happen is the landowner would make its arguments to the district court. It certainly could argue to the district court.
I mean, the district court would say, have you discussed this with the agency, you know, exhaustion. So that's why I said, could go back to the agency and say, look, you know, your certificate order was premised on the fact that everything was in abeyance. Project owners weren't going to do anything. Well, now 3 months later, they're doing all these things.
I think the commission always has the authority to stay the certificate so long as the orders are not under review by this court.
Assume it's not here, or this court remanded it so that the commission could take action. Does the commission have the authority to impose fines for violations of its certificate order? Or is that just not part of the regulatory scheme?
I'm not aware of that. I'm not aware of the agency.
So
having
what
that
relief
authority.
could a landowner get in that circumstance? FERC would simply tell the project owner you're violating the certificate order? And what would happen?
Right. I think the commission could always stay, or it could withdraw the certificate order if circumstances were so extreme. I think that authority would lie with the commission. I mean, and that would be a pretty extreme remedy if this is
Well, I'm trying to
multi-billion-dollar
understand what
project.
the landowner does. I mean, this court has been concerned about that. And indeed, we had an in-bank case expressing our concern about how landowner complaints are handled. So I'm just wondering here, the commission proceeded on certain assumptions and assurances by the project owner, and it turns out those circumstances have changed. So the basis for the certificate order is now, I don't know, in doubt, question. I mean, what does FERC have any sort of authority? To tell the
I think it's
landowner
just the authority over the certificate itself, which is a pretty powerful remedy. The
So
ability
it could issue an order directing the project owner to stop the
yes,
eminent
yes.
domain, or go to the district court where the eminent domain proceeding is pending.
Well, I don't think you would have the authority to prevent an applicant from seeking relief in the district court, but it could take action on a certificate. It could order a stay, it could invalidate the entire certificate, it could attach additional conditions on the certificate. I mean, these are the usual tools within the agency's toolkit. I mean, I don't think
So
that
I'm assuming here that the agency was convinced that the project owner was speaking in good faith, that it wasn't going to do all these things that the landowners were concerned about, absent it getting the state permits.
Well, in that circumstance, if the applicant got the state permits and had not committed to not do eminent domain, I'm sorry, I'm not being articulate. If the applicant makes a commitment that is not going to proceed with eminent domain while it doesn't have the state authorizations, then that's one thing. And if it gets those state authorizations, then I would think it's entitled to proceed under certificate orders. I mean, of course, if the applicant makes a commitment, it's not going to proceed on eminent domain at all, period, then that's a different situation.
Well, FERC didn't have that before it, as I understand it.
That's right. It wasn't before the commission. So this is all complete speculation on my part, I have to say.
No, I know. I'm sorry to put you on the spot, and I'll just cease my questions. But
It's all right, Your Honor.
You knew something about that. Okay, thank you. Any further questions? Thank you. All right, well, why don't we hear from petitioners in reply?
Thank you, Your Honor. I'm going to be very brief. First of all, in response to your question, all we have is a valid certificate, and Pembina's promised that until we decide to start condemnation, we're not going to start condemnation. FERC has no jurisdiction to touch that certificate right now. It can't do anything with that certificate. And there's nothing that a district court can do. The district court looks at it and says, this is a valid certificate. Pembina made a commitment not to start condemnation until it decided to start condemnation. They're starting condemnation, condemned. That's it. FERC can't do anything, and the district court can't do anything if Pembina simply changes its mind. That's the problem. Okay, let's on the other issues.
And it's too late to file a petition for rehearing?
A petition for rehearing of Pembina's.
Well, I mean, the assumption that my question was that FERC proceeded in good faith based on a good faith acceptance of the good faith statement by the project owner. Now it turns out that things haven't turned out that way.
Your Honor, I'm not sure I understand what the good faith statement that Pembina made that FERC
And
relied
we're
on.
not going to do this so long as we hold this in abeyance, and we're not even sure we're going forward with this project at this point. And in any event, we understand we'd have to get the state permits.
That statement came long after the FERC's process was done. They'd issued the certificate, they'd reheard it, and they'd sent it to this court. And this court, it was being briefed in this court. FERC didn't rely on that statement at all. Zero. Literally, their process was over and closed for months before, maybe even more than a year before Pembina made this completely voluntary statement. And today, they have no, so they didn't rely on it in any way, shape, and form. And today, they have no authority to do anything to amend or change that certificate, period. And if Pembina goes to district court, they have a valid FERC certificate that the district court has to honor. And our brief is chock full of cases where district courts saying, hey, condemnation, if you have any problems with the certificate, your job is to go to the relevant court of appeals. Our job is simply to do condemnation. The certificate's valid. You know, Pembina promised they wouldn't do it until they started doing it. Well, they started doing it. So I'd just like to go down quickly on a couple of things. First of all, Judge Wilkins, it's the pipeline coming down from Canada has no on-ramps. No gas comes onto that pipeline until it gets to the junction in Oregon, where the Pacific Connector will go one way, and there is a pipeline, the Ruby pipeline, that comes in from the Rocky Mountains. The problem is FERC has said repeatedly that what FERC has said is that the applicant can't, not that the applicant needs the gas, but the applicant meet the quote purpose of the project. And the applicant, as we say in our brief, the applicant defined the purpose as using Canadian and US gas. They're correct. You can't meet the purpose of the project, but there's no obligation, zero, to use a molecule of US gas, none whatsoever. And all of the evidence in the record
But Mr. Bookbinder, can I just say, I understood Ms. Chu's point and FERC's statement about benefit to be the possibility, right? That you're building an infrastructure, a pipeline that now will provide the possibility for gas producers in the Rocky Mountains to merge their gas. I don't understand that it's necessary at this point to establish that they've already lined those people up. We have some evidence in the record that there are individuals who say, yeah, if this were built, that would give me the opportunity to sell my gas through this pipeline and generate revenue. So I'm concerned about the suggestion that we don't have a benefit, a foreseeable benefit from the construction of this pipeline domestically, unless we already have people who have committed to using this pipeline in the way that you're suggesting.
Two things, Your Honor. It can't transport US gas if all the gas in the project is going to be coming from Canada. So the fact that
they dispute that. Let's assume they're correct that this pipeline will provide the opportunity for US gas coming from the Rocky Mountains to be merged with the Canadian gas and then ultimately exported. All right, assuming that to begin with, my question is, do we have to have the people on record with a contract saying, I'm going to use this pipeline domestically to put my gas in? Or is it enough that FERC says this will create access? I don't quite have the language here, but that this will create access. Why isn't that a significant domestic benefit, the potential?
Oh, FERC has never issued a certificate on the grounds that maybe someday in the future, some unknown entity will use the facility.
No, that's part of it, right? We have a terminal that has said we are going to buy this gas, or we're going to use this gas, and they're going to use it for export. No one disputes that that's the case. We have those contracts, all right? And Congress has said that such an exportation arrangement is in itself presumptively a public benefit. But FERC says, okay, in addition to that, we see that the creation of this pipeline will open up or provide access for domestic exporters to merge their gas, and then ultimately it will go to the terminal. So my question to you is, why do we need anything more than at least this terminal saying we are going to export this gas, and the possibility that domestic gas will be funneled into this same pipeline?
It would, given that FERC has never issued a certificate based on the possibility that at some point in the future, somebody will use that pipeline,
we know the terminal is using the pipeline. The terminal says we're using the pipeline. We have a precedent agreement, 98% of the gas, we're going to use it when it comes to us and export it. Right?
Yeah.
So that's a done deal. My question is, with respect to your argument about domestic usage. I mean, I get your point that if all of the gas was originating in Canada, going to the terminal and being exported, one might question whether this had any domestic benefit.
This isn't, excuse me, saying that someone may use it from the Rocky Mountains based on a couple of letters that oil and gas producers signed saying, yes, we could use this at some point in the future. That's not a basis for issuing a certificate of public convenience and necessity. And FERC has never, ever done that. They want proof that this would be, I'm truly stunned that the idea that, hey, we may use that pipeline, a few years from now, whenever they stop with the Canadian gas, who knows when that'll happen. But let me turn away from that to the export issue. And as we said, the terminal has no contracts for anybody. And if there was ever a time for FERC to look behind, which they refused to do, they said, we don't look behind contracts. We never look behind contracts. We can't look behind contracts. And that was exactly what this court said in EDF versus FERC. Say, you can't stick your head in the sand like an ostrich. You have to actually look at the facts concerning that contract. And it's when it's with a buyer who has no customers, there's no justification.
But aren't those cases different precisely because they're talking about the potential of the gas being used in the domestic market? I'm trying to reconcile all of these different factors, and I'm suddenly feeling as though we may actually have a different animal here, which is, precisely for the reasons that you point out, that this 100% of this gas is going to be exported. And so I don't know that the cases in which in which the court is concerned about the use, the market demand domestically, actually even apply in a real way in this situation, right? We have 100% of this gas going overseas. Everybody knows that. And we have a binding contract with the terminal that says we are going to liquefy the gas and use it for that purpose. So cases that talk about, domestic need and whether or not there's really a market in St. Louis and the what don't seem quite to fit because they're not addressed to this unique pipeline circumstance, right?
No, Your Honor, this unique pipeline circumstance has far less justification than any of those pipelines. So let me go to the export issue and the benefits of export. The Section 3 argument that FERC says Section 3 is important. DOE has found these things, and therefore we can incorporate or even rely on DOE's finding.
Why, can I just say, Mr. Buchman, why doesn't that cut exactly against what you just said, right? Rather than FERC being on its own evaluating the domestic market, in St. Louis or whatever, we have another agency that has signed off and certified on the export circumstance. So we don't have to worry that the gas is going to get to the terminal and just sit there and, never be used and not be important. DOE has said we have authorized this terminal to export. We've created now an actual arrangement where the gas is going to leave the United States pursuant to Section 3, check. So well, I think we should be relieved by that. Like, this is a better situation than the ordinary Section 7 determination in terms of the gas being used and presumably needed.
Your Honor, that's not what DOE said. DOE simply said, if you want to export this commodity of gas, That's fine. It's in the public interest to export gas. They didn't say that that there are buyers for it. They specifically say, in fact, in the writer, we don't anticipate that we don't make any findings or anticipate that they're going to be buyers for all of the LNG that we're authorizing.
So let me hypothesize, if they had said that in this case, different case, hypothetical, DOE does say, we see the buyers, we have the letters, we know it's going overseas to a particular place. Does that alleviate your concern about public necessity in this situation?
Yeah, no, it does not, because Section 3, which is what DOE is operating under and which FERC relied on here, the one distinction, the one difference between Section 3 and Section 7 is that Section 3 does not grant eminent domain authority. So the district gas case that from this circuit said, hey, Section 3 is the same as Section 7. You can apply all the exact same conditions and modifications and orders under Section 3 as you do under Section 7.
All right, so your argument using that distinction is merely that an arrangement for the exportation of gas is unlawful. You cannot take land, you cannot create a pipeline exercising your eminent domain authority if the gas is going to be wholly exported. Is that the bottom line?
Yes, that is absolutely correct. You can't use eminent domain for export. And I want to read to you what FERC said in its certificate order, which is, we view DOE's approval of Jordan Cove's application to export LNG to free trade agreement nations as sufficient evidence of market demand. In other words, we're letting DOE say, simply because it's okay for people to sell natural gas, it's not going to be bad for the United States. It's in the public interest to sell natural gas, that's good enough.
So ultimately, I appreciate this because this is very helpful and clarifying. You cannot use eminent domain for export, even though Congress has made clear in Section 3 that exportation is a good thing. It's a public benefit. I guess we're basically weighing the potential people who are in the gas industry in the Rocky Mountains and could use this pipeline for export against the interests of the landowners for whom the land is taken. Is that sort of where it comes down at the end of the day in terms of assessing public benefit?
Actually, no, because in 2016, when they denied the certificate for this project, the same thing, Pacific Connector said, look, DOE approved this and you should rely on it. And the 2016 certificate denial, which is at 154 FERC 611190, paragraph 40, Pacific Connector is essentially asking the commission to rely on DOE's finding that authorization of the commodity export that with the public interest as sufficient to support a finding by the commission that the Pacific Connector pipeline is required by the public convenience and necessity. The commission has not previously found a proposed pipeline to be required by the public convenience and necessity under NGA Section 7 on the basis of a DOE finding under NGA 3.
All right, so yes, excuse me, finish your answer if you will.
So that's, I mean, in 2016, they did this, they said, you should rely on Section 3. The DOE finding is conclusive. And they say that here. They said it there, FERC rejected that. And yet FERC accepts it now and says, this is sufficient. This is sufficient.
Anything further?
No, Your Honor.
Thank you. Any questions by my colleagues?
Yeah.
Thank you.
Thank you. All right, we will move on to the National Historic Preservation Act issues. Counsel for Petitioners.
They should be.
Thank you. May it please the court and counsel, Philip Thonis on behalf of the state of Oregon and its agencies. In enacting the Natural Gas Act, Congress expressly preserved the state's authority to conduct Clean Water Act and Coastal Zone Management Act review of a proposed gas project. Those statutes, in turn, both require that an applicant for a federal license or permit, including FERC authorizations under Sections 3 and 7, first demonstrate compliance with the CWA and CZMA. Indeed, Congress made clear in the text of each of those statutes that no license or permit shall be granted until the certification that is required under the CWA or CZMA has been obtained or has been waived by the state. In this case, it is undisputed that Pembina has not received Clean Water Act or Coastal Zone Management Act approval from the state of Oregon.
So you're
Indeed.
challenging conditional certificates.
That is correct, Your Honor.
That FERC has no authority to issue such a certificate.
Well, and I
Is
would,
that your position?
I would qualify that statement by saying the state does not take the position that FERC may not issue a Natural Gas Act certificate that is conditioned on future compliance with state or federal regulations or statutes under any circumstances. Our argument here is that the state of Oregon, specifically the Oregon Department of Environmental Quality, the agency that is tasked with administering Clean Water Act requirements within the state of Oregon, has identified activities authorized by FERC's Natural Gas Act authorization to Pembina that may result in discharges to the navigable waters within the state of Oregon, thereby triggering, as this court explained in the Delaware Riverkeeper case, that would thereby trigger the Clean Water Act's sequencing requirement that Congress clearly enacted in Section 401 of the CWA.
What
So
is
that-
the evidence in the record that any such activity could result in those discharges other than argument in your brief? Where is there evidence in the record that that could happen given the condition that was cited by counsel for FERC earlier in the argument that no activity could take place that would, I think, disturb the ground or something to that effect?
Right. Thank you, Judge Wilkins. So environmental condition 11 does state that Pembina is prohibited from engaging in construction activities or other ground disturbing activities, including tree felling, until it has received all applicable requirements, including Clean Water Act and Coastal Zone Management Act requirements. However, in DEQ's view, there are other activities that are not covered by environmental condition 11 that the project could engage in, and specifically on page 390 of the joint appendix in Pembina's right-of-way clearing or right-of-way management plans. This would be the right-of-way for the pipeline route, that the project could start engaging in activities including road surfacing and brushing and limbing that would fall short of tree felling, but that in DEQ's view, and again, to recall the language of the Clean Water Act, may result in discharges to navigable waters. So that is the state's concern, is that despite the prohibitions contained in environmental condition 11, Pembina may still be able to engage in activities that may result in discharges to navigable waters. And that is the scenario, that is the argument that this court said was lacking in Delaware Riverkeeper, which was an argument pointing out what activity was authorized by FERC certificate that would then trigger the Clean Water Act sequencing requirement. And here the state of Oregon is relying on those activities.
As a factual matter, you point to this plan and you say, well, given this plan, this could happen. But I guess what I'm trying to get at as a factual matter, was there evidence presented before FERC that that's the way that could happen under this plan? And how did FERC respond to that evidence or that argument if it was made?
So I guess to answer the factual question, the state is not aware of any act that the project has in fact engaged in any of that activity, which of course ties back into the long discussion we've had regarding the project's current pause on its plan. But the state did raise that argument to FERC particularly in the state's request for rehearing. And FERC's response was simply to cite the Delaware Riverkeeper case for the general proposition that in some circumstances, it is allowed to issue Natural Gas Act certificates that are conditioned on future compliance with the Clean Water Act. But that doesn't answer the state's specific concern here, which is, again, that despite the prohibitions contained in Environmental Condition 11, Pembina may still be able to engage in activities that may result in discharges without, and this is the real problem, without having obtained a Section 401 permit from the state of Oregon.
All right, anything further?
No, unless the court has other questions on the conditional certificate argument, that is our position.
Okay. Any further questions from my colleagues?
No.
All right, counsel for FERC.
Thank you, Your Honor. 2 points in response to Counsel for Oregon's position. Oregon's concerns are really speculative in nature. The page in the joint appendix that counsel's referring to talks about potential activities prior to construction, such as road surfacing, brushing and limbing, and without any evidence in the record, I mean, there's no evidence, other evidence in the record relating to these activities. I mean, these activities sound like ground disturbing and tree felling activities that are actually prohibited by the environmental conditions under the certificate order. So I don't think there's any indication in the record that Oregon's concerns are actually imminent or concrete. And the second point is that the injury that the state is alleging here, the sequencing requirements of the Clean Water Act and the Coastal Zone Management Act, these are exactly the types of procedural injuries that the Delaware Department of Natural Resources brought in the case that was held in abeyance. I'm sorry, that the case that was dismissed for lack of standing. That's 558 Fed 3rd 575. It was this court's decision of 2009. And the court found there was just no concrete harm there. It's a procedural injury.
Are we back to standing? I'm trying to understand where we are.
I'm sorry, Your Honor. I didn't mean to bring us back to
it's
issue
okay,
1.
but we were at justiciability to begin with, and
Right.
I'm trying to understand whether FERC considered any pre-construction activities. I know that its conditions relate to the actual construction of the pipeline. That's not happening, fine. But my understanding was that there was a certification that nevertheless allows for the recipient, the companies, to start clearing, et cetera, et cetera. Did FERC consider that when it determined that it was going to issue the certification or not?
I think it did, Your Honor. And just to clarify, I brought up standing because the response to Oregon's argument is both jurisdictional standing and then on the merits. I think the commission's answer was that it had, it conditioned, the conditional authorization is permitted by the court, and that these particular conditions actually bar the harms that Oregon is concerned about.
But can we home in then on the conditions? Because I didn't see anything about pre-construction, clearing, et cetera. I thought they said no construction can happen. And so maybe if you could point us in the record to the conditions that prevent the kinds of potential discharges that petitioners are pointing to.
Right. So environmental condition 11 is at JA 133. And that condition says that the pipeline has to receive written authorization from the agency before commencing construction. And that does not specifically say pre-construction activities, but it includes as one of the items that the pipeline is precluded from doing is tree felling or ground disturbing activities. Ground disturbing activities is really a broad, it's a very broad range of activities.
I see. So this is really just about interpretation of the conditions then, because you seem to suggest that the kinds of activities that petitioners are worried about are included in your conditions such that Delaware Riverkeeper applies in full and we have no problem. Is that your position?
That's right, Your Honor.
Okay, so when on rebuttal, I'll ask petitioner's counsel whether he reads these conditions in the same way.
Right, Your Honor. And I think, in addition, there's no evidence that the concerns that Oregon is expressing about these pre-construction activities that that these actually will occur. I mean, it is really speculative. So there's nothing else in the record that I'm aware of about the road surfacing apart from that one page.
But can I ask, can we even isolate that? All right, so let's assume hypothetically that the conditions don't cover it. I'm not sure I understand the work of your imminence argument to dispel their claim that the fact that you have issued a certificate that does not cover all potential discharge circumstances is unlawful. I don't know what work imminence does. You've issued the certificate, it's already there. And in my hypothetical, the certificate says construction cannot happen unless you get state certification. And by construction, we mean just actually building the pipeline. You can go ahead and do everything you want to up until that point. All right, this is my hypothetical.
Okay.
All right, so in that situation, why does it matter that the company says we're on pause or that, there's no construction anytime soon? What petitioner is saying is that you've now unlawfully issued a certificate that allows for discharges to occur under a circumstance in which we have a law that says you're not allowed to do that. What is imminence doing there?
Okay, I understand, Your Honor. Well, first, I think imminence really goes to the standing argument. So it's really standing, but it's also a little bit on the merits. I mean, it's the fact that there's no evidence about the connection between the potential discharges into the waters of the state and any of the potential activities like, road surfacing. Like, there's nothing else in the record about how road surfing might result in.
Right, but isn't that his point exactly? Ferc, yeah. It would be on Ferc to develop the record to determine whether discharges could happen from other things and either cover it or not in their certificate. So it's not the petitioner's burden to point out every circumstance in which discharges could happen, right?
Right. No, you're right, Your Honor. In your hypothetical, yes, I understand. And our answer here is that the conditions do cover these.
Okay, so that's the answer.
All right, so let's hear from petitioner.
Do the conditions cover it?
No, Your Honor, they don't. And this brings up the interpretive point that Judge Jackson raised. If Pembina reads the condition narrowly, environmental condition 11, and decides that, hey, road surfacing isn't covered because it's not construction and we don't think it's ground disturbing and we're not cutting down any trees, then we can go ahead and engage in this activity. But the problem is, like Judge Jackson pointed out, we don't know if that activity may result in discharges to the waters of the US. It's possible that it might, and the proper forum for determining that is in Pembina's Section 401 application in front of the Oregon Department of Environmental Quality.
What's the remedy and what's the holding of this court under those circumstances? We have an ambiguous condition, right? It could or could not cover activities that you say would cause discharges, and yet you appear to want this court to hold that the certificate and that the certification, the authorization by Ferc is therefore unlawful because it might allow. Is that your holding?
Correct.
And the question going back to Judge Wilkins is, did you present these arguments to the commission that condition 11 was ambiguous and that it left open the possibility of unauthorized discharge?
Yes, the
And
state,
did you, on rehearing, say that condition 11 was still ambiguous?
yes, yes, Your Honor, the state pointed to the,
Why? That's what I don't understand.
I'm sorry, I didn't,
What should FERC have said in the condition so you don't think it would be ambiguous?
well, I guess this gets to a more fundamental problem that the state believes that the Clean Water Act process should, as a matter of practice, always be done before FERC is issuing.
We understand that, but I'm asking you now, your argument is that that hasn't happened. And
Correct.
we're afraid of activities like tree felling, road clearing, discharges.
Correct.
Where did you say to FERC, condition 11 doesn't reach those things?
In the state's request for rehearing, the state pointed, and I'm sorry, I don't have the precise record site, but in the state of Oregon's request for rehearing, the state pointed to the activities that we then cited in our brief to this court, such as road surfacing and brushing and limbing.
I know, but the problem I'm getting at is, of course, there can be road surfacing. Of course, there can be tree felling. But why is any of this, likely to happen, given the nature of the certificate that says you can't go ahead until you get these state certificates?
Well, I guess
That's why I asked you specifically, what language is missing from the condition or another condition?
well, I
That would
suppose it,
clarify what you posit as ambiguity.
so if environmental condition 11 said the project is prohibited from engaging in any activity that may result in discharges, so basically any activity that would fall under section 401, that would be better than the way it's currently written, but that still brings up the problem of
Did you ask FERC to put that language in the condition or a condition?
not that precise language, no.
No, that's my point. And that, let me ask you then, suppose the project owner starts felling trees. What can, and before it has its permit, state permit, what can the state do? Can it go to state court and get an injunction?
I'm not sure, Your Honor. If the project,
Well, why couldn't it?
I guess it
Because you're
could, but
felling trees and you don't have a permit.
the project's response at that point would, I assume, would be that we're not doing anything. Well, felling trees would be covered in environmental condition 11. So at that point, the state would go to FERC.
How about ground disturbance?
That would be the same if the state believed
Oh,
that
it's
the project
covered.
was right. But our point is that there are things that the project could do that
I
wouldn't
know, it
qualify.
could do all kinds of things, and FERC is trying to write conditions that are broad enough to cover what parties have brought to its attention. So it says you can't do these things. And you can't expect FERC to put a condition that you can't do anything that the state agency in Oregon says you can't do.
Well, yes, but the Congress also, part of the sequencing requirement in the Clean Water Act is that Congress contemplated that any condition that is a part of the Section 401 permit itself is also incorporated into the license or permit that required the Section 401 permit in the first place.
I
So
thought
again-
your concern was that there had been pre-certificate authorizations. And
Right.
that the state was concerned that the project owner would rely on those in going ahead, hypothetically, maybe someday, discharging into Oregon's waters.
That's correct. That is the concern, and that those discharges would have no Section 401 oversight.
Okay. Anything further?
Can I just ask one other question? I'm trying to understand the extent to which this particular point, the point of look at paragraph 11, I think it's ambiguous. It can allow for these kinds of activities. Was that point raised with FERC below?
Yes, in Oregon's request for rehearing, again, I
What did it
apologize.
say specifically?
Essentially what we said in our brief to this court, which is that
No, I wanted
these-
you to say it's in the petition for rehearing. FERC didn't have your brief, it had your petition for rehearing.
right, and we made the same argument that we made here, which is that these are
So I
the,
tell you what, counsel, will you submit something that shows us specifically where in your petition for rehearing you said that condition 11 was ambiguous and should be revised to say X, Y, and Z?
of course.
Thank you. Any further questions? All right, thank you. So, where are we here?
I think
Counsel
the
for
issues
FERC.
are the only thing left, right?
No, I think counsel for FERC gets to speak.
Well, that was on Judge Rogers. Wasn't that, didn't we already have a round on this?
Oh, did we?
I believe so.
That was the rebuttal on that point.
That was-
Thank you very much.
Mhm.
Moving on to the NEPA issues, counsel for petitioners.
Oops, you're on mute, sir.
I apologize. And my video camera just crapped out, so I'm trying to get the. Can you
Watch
see
your
me now?
language, we can see.
I apologize. So good afternoon, Your Honors. Nathan Matthews on behalf of petitioners. FERC's NEPA analysis was deeply flawed. Some of those flaws are so egregious that I don't plan to discuss them unless this court has specific questions. For example, the rejection of an alternative that would only use waste heat, and I'll put aviation in that category for today. I had planned to focus on greenhouse gases and the no action alternative, but I want to make a quick note about the tribe's NEPA claim about cultural resources. The tribes had standing to bring these claims at the time the petition was filed. Their standing was clear from the record, as FERC recognized that the pipeline would potentially impact cultural
Why is
resources.
it clear from the record, counsel? And by
Because-
that I mean, the tribes know where they're located. You may know where they're located. I don't know where they're located. And I don't know where the grounds that they're concerned about are located. And in situations where something may be obvious and where Article 3 is not a matter that's been previously raised, this court has allowed the filing of affidavits to indicate why standing is demonstrated here. How about doing that here?
I believe that would be possible here.
Because
FERC
your
also-
brief has a paragraph in it where if there were affidavits to support it, it seems to me you would show standing.
Well, I'd like to clarify that I don't actually represent the tribes. The
Who
petitioners agree.
represents the tribes? You said you just wanted to talk about the tribes.
Well, so we,
Are you representing the tribes or not?
for purposes of the NEPA argument, I represent the tribes. I did not author the tribes briefs, but for purposes of oral argument, we designated one attorney to speak on all NEPA
Fine.
issues. And that's me.
So why not ask the tribes to submit affidavits?
That would be a fine course of action. Also in the record, like at JA 636, FERC recognized that the pipeline crosses territory that was historically significant to the tribes. FERC chose to include the tribes in the incomplete NHPA process. So it was apparent to FERC throughout the proceeding and in the record that the tribes were potentially injured by this proceeding. So
Understand, FERC is not required to consider Article 3.
I agree, Your Honor. And if the court has concerns about the tribe's standing, I think that asking for the tribes to submit additional information on that would be one way to remedy that situation.
You can see the American Library case.
Yes, Your Honor. Moving on to the other issues of greenhouse gases and the no action alternative, NEPA requires a hard look at greenhouse gas emissions, their significance, and the severity of their impacts. But FERC concedes that here it made no determination on these issues. FERC mistakenly argued that it lacked the tools to do so. The failure to evaluate significance mattered and affected FERC's decision-making. In the rehearing order of JA 328, FERC explains that the reason FERC does not require mitigation of greenhouse gas emissions is because FERC does not know whether those emissions are significant, and thus in FERC's view, FERC didn't know what level of mitigation would be warranted. But FERC was wrong to claim that there was no way to evaluate the significance of greenhouse gas emissions. FERC had multiple options. One option would have been to measure the project's emissions against Oregon's emission reduction targets.
Well, they gave a response to that.
FERC gave two reasons why it said that Oregon's target was not informative here, both of which were arbitrary. First, FERC's orders claim that Oregon's targets are not backed by any enforcement authority, and that's wrong, as our briefs explain, but also FERC never explains why that would be relevant anyway. The question before FERC is whether a project that emits 2 million tons of greenhouse gases per year is something to worry about, and Oregon's targets provide a benchmark for that, regardless of any implementing authority. Perhaps for that reason, FERC doesn't defend that rationale in its brief. That's just in FERC's orders. The other response FERC gave was to say that the Oregon targets are not specific to the gas industry. And to claim that a meaningful analysis on these facts required such specificity is absurd. Oregon wants to reduce its statewide emissions by 75% down to 14 million tons per year. And as Oregon explained, if 2 million tons of that, 15% of the budget is consumed just by this new project, it'll be burdensome, if not impossible, for Oregon to meet this goal.
Well, let me ask you, in light of our recent decisions, are we not bound to send this back to FERC?
Yes, Your Honor. One way or another, what FERC did here is wrong.
You hesitated.
No, I mean, this court's recent decision identified that there are other ways FERC could have.
And we remanded.
Yes, Your Honor.
And basically rejected the type of analysis FERC has given here.
Yes, Your Honor. The difference between this case and the Vecinos para el Bienestar de la Comunidad Costera case is that here, FERC did have an option that was not available in the Vecinos case. Texas doesn't have any state emission reduction targets. And FERC has, in many proceedings over the years, said, if only we had a state emission target to compare this against, then we could do something useful.
Where have they said that?
We collect those cases in
your brief?
In our brief, both the opening and the reply, where FERC has said that comparison with state emission reduction targets would be a reasonable, appropriate way to evaluate the significance of greenhouse gas emissions.
And so here it looked at Oregon's standards. It didn't say, gee, we wish we had any standard.
Right. Here, when FERC finally had a chance to put its money where its mouth was and do the thing that it had been telling us for years it wished it could do, FERC invented these two new reasons about, well, this standard isn't enforceable, or, well, this standard isn't specific to the gas industry.
Well, from FERC's point of view, it's meaningless then. Either you want an enforceable standard or not. That's all I'm getting at, is it gave some reasons. You may not agree with them.
Well,
but why isn't an agency's concern about enforceability a non-arbitrary consideration?
Because the question is whether FERC could decide the sense of scale. And so FERC never explained why enforceability is relevant. FERC could have said, well, Oregon has a standard, but they were adopted on Tuesday, and so we don't care. And
no, but I don't understand it. If Oregon says we want everybody to reduce emissions by 80% by next Monday, but it has no way to enforce it, why would FERC think that that was a useful target?
Because
if
the question
FERC is under an obligation to do something to measure and reduce. That's all I'm getting at.
Because the FERC's position is that it simply has no way to decide what amount of greenhouse gases are a problem. Like, when does a project's greenhouse gas emissions?
It has no reasonable intellectually defensible.
That has been FERC's position, and our claim is that
all right.
if Oregon provides an answer, that the Oregon legislature considered the problem and said, we are passing a statute that declares that this level of emissions is a problem.
And how did Oregon's legislature say it was to be enforced?
Oregon didn't create any new enforcement authority for this, but Oregon
How
agencies
was this to be enforced?
We cite in our briefs and include in the record an executive order directing Oregon agencies to use their pre-existing statutory authority to try and achieve this goal.
To try to achieve this goal.
So,
what's FERC supposed to do? I mean, all right, I get your point. All right. So there was a standard and FERC could have measured using that standard.
Or alternately, if FERC decided, and actually provided non-arbitrary reasons in the record explaining why the Oregon standard wasn't good enough.
So you're opposing a remand, all right? You want vacator?
We do want vacatur. We think that under the Allied signal test that it's not sufficiently likely that FERC is going to be able to cure these deficiencies on
under
remand.
Allied signal, normally we remand without vacator where there's some indication that the agency may be able to meet its obligation. And here you're telling me, Oregon has this standard and FERC could have used it.
So
why shouldn't we give FERC a chance to do that?
Certainly, Your Honor. I think that the greenhouse gas claim in isolation may not have been enough under Allied signal to have justified remand with vacatur, but the collection of errors here cast doubt as to whether on the whole on remand, FERC would be able to reapprove the project. But our argument for vacatur is not solely hanging on the greenhouse gas argument.
All right, so what other arguments do you have, counsel? I mean, you sort of brushed past, there was one that you said I'm not going to address, and I was a little curious as to that one.
I mean, I'm just mindful of my time, and there are more claims.
So we're interested.
Okay. Well, then the final point on the greenhouse gases is that even if FERC had concluded for non-arbitrary reasons that the Oregon targets weren't good enough, that wouldn't have let FERC off the hook for the underlying obligation to say something about the significance of greenhouse gases. And as a backstop, FERC does need to look at tools generally accepted in the scientific community, such as social cost of carbon, which is what this court dealt with in Vecinos, where they didn't also have the option of a state target. I'll just point out, we argued the Vecinos former regulation 40 CFR 1522 claim in this case. It's in the landowner and conservation group's opening brief at page 62. It's in the rehearing request at J 721 and to 22. But as in Vecinos, nowhere in the record did FERC or in the briefs did FERC address the regulation or its obligation to use, perhaps imperfect, but still generally accepted methodologies to assess the significance of greenhouse gas
emissions. So if we disagree with you on that, or if we don't think it's enough for vacatur, what other things are there in this NEPA analysis that you find so objectionable that we have to vacate the entire thing?
I think that the refusal to require the terminal to use a waste heat only design is so objectionable that it would require vacatur because it implicates how they're actually going to build the facility. So if they start building and then, while they're doing the NEPA analysis on remand and then discover that actually a different design would have been more appropriate, that's a problem that should be addressed,
Right, but where did that design idea come from? My understanding of the record was that the companies initially proposed it and then changed its mind. So fine. What is it that you say is objectionable about FERC's acceptance of the company's decision that a different alternative would be necessary?
So the company is allowed to change its mind, but the company never suggested that the alternative was necessary. They just said we would prefer an alternative design. But it's not FERC's job to rubber stamp whatever the company wants. Under NEPA, FERC must do a rigorous exploration of all alternatives. And then under the Natural Gas Act, FERC has to decide which alternative best serves the public interest, regardless of whether that's a specific alternative that the company would have preferred. So here the company said that the design that would only use waste heat, not needing electricity from the grid, would be feasible. That's what they actually initially proposed. And that's what FERC addressed in the draft environmental impact statement.
But
At
I
some
thought
point,
there was a capacity issue as to what
well, so
the terminal would be able to do.
Ferc asserted in the final environmental impact statement and the rehearing order that the terminal wouldn't be able to do it, but there is literally nothing in the record to support that statement,
I
including
thought
the
it
company's.
referenced specific percentages.
I am not aware of anything in the record explaining why the terminal would be incapable of meeting its needs solely from waste heat. And both the company and Ferc thought that that design was feasible when they proposed it and considered it in the draft environmental impact statement. So there was an abrupt change in position from Ferc and nothing to explain or even acknowledge that change in position.
All right, what else? I think we have, there's wildfires, there's thermal plumes. What else is supporting your view that we have to vacate this entire environmental impact statement?
So on the aviation and the thermal plumes, that's another issue where if the certificate isn't vacated and they're allowed to start construction, it may be too late to fix the problem by the time they've finished a renewed analysis on remand. The terminal is directly across Coos Bay from the region's only airport. The Federal Aviation Administration has said that industrial facilities near airports are a problem. The terminal will burn a lot of gas. It creates this plume of hot exhaust, and the rising air creates problems for planes during takeoff and landing. According to the FAA, such thermal plumes are, quote, incompatible with nearby airport operations. So, FERC tried to pass the buck on this issue, first to the FAA, and the FAA said, no, we don't have any authority over thermal plumes from the terminal. Then FERC tried to pass it to the airport, but the airport and the runway are already there. They can't move out of the way. And there's nothing in the record that suggests that if the thermal plume proves to be a problem and it's dangerous to take off or land from this runway, that there's something the airport can do to work around it. So NEPA requires a hard look at that type of impact now before construction begins, but remand without vacature would allow construction to begin before that issue is addressed.
And is eminence an issue in this regard, right? I mean, as we determine whether or not to vacate, isn't the fact that there is no construction at issue relevant to that determination?
Yes, it is, Your Honor, but it cuts in favor of vacating the order here, because under Allied Signal, you look at hardship to the other side. And here, there's nothing to suggest that vacating would actually impose any burden on Pembina, because they have said they don't even know, they're non-committal, but they're saying they don't know whether they're going to proceed with the project. So they're not, this is unlike in the Vecinos case, where the developer said, we really are ready to go now. Please don't vacate this proceeding because it'll disrupt our ability to get financing, et cetera. Here, Pembina isn't even showing up. So they aren't asserting that vacature would impose any hardship on them. And I think that does factor into the Allied Signal analysis.
Wildfires?
Unless Your Honor has specific questions about wildfire, I'm comfortable to rest on the briefs there.
All right. Anything further?
I'd like to briefly address no action. On the no action alternative, FERC arbitrarily declared that denial of this project would just shift rather than prevent environmental impacts, because FERC claimed that some comparable project would be likely to take this project's place. That's factually and legally incorrect here. Factually, there's no support for the assumption that if this project is denied, some substitute would be proposed. There is no evidence of market demand or market support for the terminal. I want to respectfully amend one point that my colleague said earlier today about the difference between the DOE authorization and the FERC authorization, which is that the burden of proof is flipped for Section 3. The DOE just says, are they worried that this project would be contrary to the public interest? And DOE makes no findings about market demand, about whether there are any potential customers. In the DOE's authorization here, JA 440, DOE says that they expect that a lot of the projects that they authorize are actually never going to get built because there aren't customers for all of these projects. So DOE hasn't found that there's any market support for the terminal, nor has FERC. And without the terminal, there's no demand for the pipeline. So there's no support factually for FERC's assertion that, well, if we deny this project, somebody else is going to propose something similar. But legally, any substitute project would also require FERC approval. So the adverse impacts of a project like this, whether from this project or some substitute, are not inevitable. If the adverse impacts are a problem, FERC can prevent them by refusing to authorize both this project and any comparably harmful substitute. So that flawed no action analysis matters because it skews FERC's decision making. What FERC has said to decision makers and to the public is that environmental harms aren't a reason to reject this project because the equivalent harms are going to occur anyway. And that is just plainly incorrect. So ultimately, FERC's treatment of the no action alternative exemplifies the problems with FERC's approach to the entire project. FERC has consistently downplayed its own role. It's positioning itself as at the mercy of markets or is able to defer to other authorities. But FERC is the lead regulator for these projects. FERC has greater authority and responsibility than anybody else in deciding whether and how these projects should proceed. So this court should vacate and remand so that FERC can exercise that authority consistent with FERC's statutory obligations.
All right. Any questions, my colleagues?
No.
All right, let us hear from counsel for FERC.
Thank you, Your Honor. Let me start with the vecinos issue. That very recent decision, it's not applicable here. I understand that the petitioners raised that regulation in passing. It's 40 CFR section 1502.21. So it was raised in passing, but it's not the same situation as in vecinos where the commission didn't address an argument based on that particular regulation. The commission made clear here it's in the context of these orders and on the record before the agency, it could not make a meaningful determination about the significance of this particular project. It did do a significant amount of analysis relating to greenhouse gas emissions from this terminal and pipeline. The commission calculated the direct emissions. It also compared the amount of emissions from the project to the emissions targets of Oregon. But it did find that the Oregon state reduction targets were not an objective benchmark that the agency, the federal agency, could objectively use to determine whether
record, Ms. Chu?
That is in around JA 113.
So it looked at the Oregon standards?
Yes, Your Honor. So beginning at JA 112, the commission has a discussion about greenhouse gas emissions. It first explains that at the time the order issued, the national emissions reduction targets under the EPA's Clean Power Plan had actually been withdrawn. So those weren't available for use. And then it goes on at paragraph 260 to discuss the Oregon targets, which are to arrest the growth of Oregon's greenhouse gas emissions and reduce those emissions to 10% below 1990 levels by 2020 and 75% below 1990 levels by 2050. That's in paragraph 260. So the commission, while these goals may be laudable, the commission did not find the state targets to be an objective benchmark that the agency could use in these circumstances.
Did the commission say why, or did they just in 260 identify those benchmarks? In other words, did they critique Oregon in the way that you are now in this discussion?
Yes, Your Honor. It's at paragraphs 261 and 262. That's where the agency does compare the emissions from the project to the Oregon goals, and it acknowledges that the project would make up 4.2% and 15.3% of the 2020 and 2050 greenhouse gas goals. But then it goes on to say in paragraph 262 that the emissions goals are not the same as an objective determination that the greenhouse gas emissions from the projects will have a significant effect on climate change. And the commission also, sorry.
I'm sorry, go ahead.
Well, the commission also noted in footnote 559, the state itself took these emissions targets into account when it denied the authorization under the Coastal Zone Management Act. So, you know, it was entirely appropriate for the state to take its own emissions targets into account in its own decision-making regarding the permits for this project. But the commission determined that it wasn't a meaningful benchmark for the federal agency to use.
Okay.
So let me just be clear that I understand what the state was saying here, or that rather the commission was saying, was where Oregon had these goals of emission reduction, and Ferc was able to measure the amount of emissions from the project. What's missing?
I think what's missing is that while the state's goals may be laudable, they're not necessarily an objective indicator of what level of emissions is significant from a climate change perspective. I think that's what's underlying the finding here.
Can you please address the no action alternative argument that Mr. Matthews and the petitioners have put forward?
Sure, Your Honor. I think that the no action alternative analysis here is substantially identical to the commission's analysis of the no action alternative in other pipeline cases. I think it's at bottom, it's consideration of an alternative where the project doesn't get built. But the commission did also find that, if this particular project didn't get built, it was quite likely that other project proponents would come forward and propose a similar project, whether or not it's at Coos Bay in Oregon, it could be elsewhere, but it did find that there was demand for this project and it would get built. I think Judge Wilkins
has this court ever accepted such a broad blanket, unsubstantiated statement by FERC? My understanding of the no action alternative is that it really has to have some support. In other words, you look at what the world would be like if this alternative was not in place, and there's some evidence of that world. There's some analysis of the tons of gas that would get shipped anyway, and how it was likely to happen, and what the environmental impacts of the alternative world would be. Here, it appears we have like a sentence, a speculative sentence that just says, well, because there's market demand as determined by DOE, even if that's true, okay, because that's the case, we find that the no action alternative would end up in the same place as we are today, without anything more. And I've never seen a case in which that was posited by FERC, used by FERC, or endorsed by the court.
Well, Your Honor, I think the court has endorsed the commission's no action alternative in other cases, although, to be honest, I can't recall a specific case citation right now. But I think it's more than just that one sentence. The environmental impact statement does have a discussion of the no action alternative. It's a few paragraphs long. It's at JA 534 and 535.
I may have looked at it. Let me see. I mean, I feel like I did not see what a substantiated assessment of what the world would look like in the absence of this project, right? I see on page 535, given that the project is market driven, it is reasonable to expect that in the absence of a change in market demand, if this project isn't constructed, exports from other facilities may occur. Thus, although the environmental impacts associated with this project won't happen, right? Impacts could occur at other locations. And then in the next paragraph, it says, we do not consider the no action alternative further. It doesn't tell us how those other impacts could occur. What are the circumstances in which the gas would be transported in the absence of this? We have no other real detail or analysis about the world of exportation in the absence of this proposal. And I thought that's what no action alternative requires the agency to do.
Well, Your Honor, I'm not sure of the level of detail, to be honest, that is required under the case law, because I think that this is a full description of what happens. I mean, if the project isn't built, there are no environmental impacts, right? I mean,
I think the question is, this court has endorsed repeatedly where these expert agencies opine on predictions. And what Judge Jackson is raising, as I understand it, is it enough to say, look, there's so much money involved in what's going on here, and the Asian market is growing like crazy. So somebody's going to come here. Now, Ferc doesn't say the Asian market is growing like crazy and that type of thing. So can we take judicial notice of these types of things? Because we all know it is growing. And this company has been doing this for how many years now? And maybe they'll decide they just spent too much money and they don't want to go forward. But they're not building this pipeline for any non-pecuniary reason. This is cold cash business.
And if I might, Judge Rogers,
yeah,
even if we could take judicial notice of the fact that there is a market for this, my understanding is the no action alternative requires the agency to go beyond that, because you could say that in pretty much every pipeline scenario, right? I mean, that's not really a finding. In the no action alternative world, right, you could always say, if this pipeline wasn't built, there would be no environmental impacts from this pipeline.
Well, we don't need to debate among ourselves, but I don't see our cases having said that, where we're talking about these expert predictions. But Judge Jackson may be right. But I just didn't see a case, and I'll look for one. But at any event, maybe this isn't enough.
Well, Your Honor, I think the court has recognized that the agency, as the administrator of this particular statute, is entitled to make predictive judgments. The agency does have numerous gas pipeline cases before it at any given time, and is aware of what's going on with the markets, the gas shortages, the demand in Asia. I think the court could take judicial notice of that. I think.
Well, I guess then the question is, if it's going to do that sort of broad statement, doesn't it have to tell us something? And I can think of cases, I can't tell you a name, and you're probably familiar with them, where in these no action alternatives, the agency has gone to great lengths to explain the shortcomings of not doing anything, etc. Here, they didn't do that. So I'm wondering, when we send it back, if we send it back on another issue, we can ask the agency to spell out.
Oh, of course, the court could do that. But I think the path to the commission's reasoning is clear here. That maybe it didn't go through every single detail, but
well, no detail. I mean, you just said we know something's coming. If you don't build it, someone else will. That's all it's.
Right, and that's where the agency was relying on its expertise and its predictive judgment. But of course, it would be possible if the court desires more explanation.
No, I
agency could
understand that,
apply
but I thought Judge Jackson's question was getting to the legal point. Is that legally sufficient? We've got lots of expertise out there, but that doesn't always suffice.
I'm not aware of any case that would hold that explanation to be legally insufficient, taking it from the other side.
Well, maybe there's never been such.
That's entirely possible, Your Honor.
All right, so we can look at the case law and see what's required. But you don't have any further, although you have cited us now to the EIS.
Right, no, I don't, Your Honor.
Okay, all right. Anything further? Any questions from my colleagues?
No,
All right. Why
Judge-
don't we give petitioner a
Oh,
few-
sorry, Your Honor.
Oh, sorry, yes, did you have?
I'm
something?
sorry, did you want me to just briefly address waste heat and thermal plumes? I think,
Oh, sure.
okay. So I think Judge Rogers, you were right that I think there was a capacity issue here. The commission, the commission said it, the terminal needs about 40 to 50 megawatts to operate, and 24.4 megawatts would be supplied by waste heat, but the rest has to come from the local power grid. I think what petitioner doesn't explain is why it's preferable to have all of the heat, like why it's better to have waste heat power the entire facility rather than have some of it come from the local power grid. So that's just not clear to me from what petitioners are
Haven't we
arguing.
long held, Ms. Chu, that arbitrary and capricious review requires us to analyze whether the agency has provided a sufficient explanation for a change? So I understand the change came from the company, but according to Mr. Matthews in the record, it was initially posited that waste heat was going to be the source and that there was suddenly a new course of action that Ferc never really acknowledged or explained. Is he wrong about that as a factual matter? And if so, where in the record does Ferc explain the shift from the initial proposal regarding waste heat to what we have today?
I don't think Mr. Matthews is wrong that it was initially proposed by the company and then the company changed its mind, but I don't think the requirement that the commission has to explain any course reversal, like that requirement applies to commission decisions. And I don't think that there is a course reversal in the commission's orders that has to be explained away here. So I think it is sufficient that the commission found this to be.
So you're saying the commission never passed on the initial proposal? It never agreed to or thought of, and maybe not as a final matter, but it is that your point?
I think so, Your Honor, and I'm sorry about this, that I don't recall if the agency actually ever passed on the initial proposal. But I'm pretty sure that.
Well, we're many hours in, so you're excused for
Thank you.
this moment.
I didn't see it in the briefs, but any reference to it, but that I haven't read every page of the record either. Okay.
Right. I don't think we did. And as the thermal plumes, the commission wasn't trying to pass the buck, but this court has recognized that the agency is entitled to rely on the expertise of other agencies and other parties. And
Right, but here the FAA, it didn't rely on the FAA's view, did it?
well, it did. It relied on the FAA. The FAA conducted aeronautical studies. And it found that the LNG terminal does not present a hazard. And that's at JA 106, paragraph 245 of the authorization order. But then there's also a 2015 FAA memorandum, which just simply said that airport operators should take potential thermal plumes into account. That's discussed at the rehearing order, paragraph 196, JA 302.
So what was Ferc's view about this? That plumes are going to be, coming up, and they're going to be in the pathway of planes that are, leaving and arriving at the airport.
But no, they're not necessarily, Your Honor. I mean, I think FERC's view is that the aeronautical studies concluded, the FAA aeronautical studies concluded that there's no hazard, there's no, specific hazard, but the potential for any thermal plumes, like the FAA said that was highly dependent on specific factors relating to proximity of any exhaust stacks to the airport flight path, the size and the speed of the aircraft, local weather patterns. And
Right.
these are all factors that are just uniquely within the airport's knowledge and
So
purview.
instead of going out runway 2, they'll go out runway 3.
Right,
That's the
exactly.
theory.
Exactly. And that's for
Can
the
I
airport to
quickly ask
decide.
you, I'm mindful of the time, but I'm looking at paragraph 245
Yeah.
on JA 106, and it says that the FAA completed these aeronautical studies following the issuance of the final EIS.
Right.
So tell me isn't that a little problematic to the extent that the EIS was already done? The agency could not have relied then on the aeronautical studies, and didn't the agency err in issuing the certificate on the basis of an EIS that did not in fact rely on these aeronautical studies?
Well, but the certificate order relied on the aeronautical studies and the EIS. Like both of those were complete by the time the order issued.
I see. So the studies came into the certificate order?
Yes.
So they had not been, okay.
I think that's right. Yes, yes.
Okay, anything further? My colleagues, any questions?
No.
All right. Counsel for petitioner, do we give you a couple of minutes here?
Thank you, Your Honor, and thank you for hanging in on this very long day. On aviation, the FAA's aeronautical studies explicitly refused to consider thermal plumes. Many petitioners here asked the FAA to consider that, and the FAA said, no, that is someone else's problem. And the FAA memorandum says that it could be a problem for airports, like if the airport is planning an expansion, they should see if that expansion is going to bring them running into a thermal plume. Or the FAA said federal, the permitting agencies, other than just the airport, also need to consider thermal plumes. On waste heat, I am confident that there is nothing in the record where FERC explains the basis for its statement that a waste heat only alternative would be infeasible. I mean, FERC doesn't just say that we're not adopting it, they say it would be infeasible, and that statement is unsupported.
But I thought they went through I can go back, the percentages. In any event, okay. So no support for infeasibility. That's your point.
On greenhouse gases, if FERC didn't like the idea of using the Oregon targets, FERC needed to do something else. That is the former CFR 1502.22 argument. But also, FERC criticizes the Oregon targets for not providing an objective determination, but there's never going to be an objective determination for significance. It requires the exercise of judgment. That's not unique to greenhouse gases, that's for everything. And if FERC didn't feel like it could make that judgment itself, it would have been appropriate for FERC to look to the judgment of the state. FERC says, well, Oregon considered its targets in the CZMA denial, but there are issues uniquely within FERC's jurisdiction where FERC needs to consider greenhouse gases. FERC has to decide.
Can I ask you, Mr. Matthews, just quickly, I'm trying to isolate whether this is a blanket FERC policy, because I've seen this happen in a couple of cases where FERC does not address the significance of greenhouse gases, or does FERC do it sometime, but it didn't do it here because of its concerns about Oregon's methodology in some way? Have you ever seen FERC estimate significance of greenhouse gases?
Aware of only one case in which FERC reached a determination about the significance of greenhouse gases. That was the recent pipeline matter discussed in a footnote in FERC's brief and our reply, where that was such a small project that FERC said, here we're comfortable writing this off as de minimis and insignificant. I think it was like 20,000 tons as opposed to the 2 million tons we're looking at here.
So it's only cited in footnotes, right?
Yes, Your Honor, and it's post-decisional here. That came after the authorization here. I am not aware of any proceeding in which FERC has concluded that greenhouse gas emissions are significant, or any proceeding other than that one where it wrote them off as de minimis, where FERC has said here would endorse a methodology for making the decision. It's not that FERC is always saying these are insignificant, it's that FERC is refusing to answer the question at all. And FERC gets to pick in the first instance what methodology it uses. If it was me, I would probably use social cost of carbon. FERC doesn't like social cost of carbon, but FERC had said, well, we would like to use state targets. So sure, if that's what FERC has said it wants to use, it could start with those. But FERC can't just refuse to do anything. But that's, in our view, what FERC has done, and we're not aware of any other examples of FERC finding some other approach to the problem.
All right, thank you. Any further questions from my
One-
colleagues? All right, thank you, counsel. All counsel will take the case under advisement.
This honorable court is now adjourned until Monday, November 1st at 9:30 a.m.